before receiving same. It was not possible to obtain the said evidence before the trial at the court below. 17. The deposition was made on October 3 after the conclusion of trial at the court below and was not available to be tendered at the trial court. 18. Presentation of a forged certificate to the INEC by a candidate for election to the office of President of the Federal Republic of Nigeria is a weighty constitutional matter requiring consideration by the court as custodians of the Constitution. 19. The original certified deposition has been forwarded to the Honorable Court by a letter addressed to the Chief Registrar of the Supreme Court. And 20, the last, it is in the interest of justice for this Honorable Court to exercise its discretion in favor of the appellant applicants. In support of the said application is a 20-paragraph affidavit deposed by Uyigiwa Osage, Nigerian citizen, a legal practitioner, and legal advisor to the first appellant, with exhibits A to H annexed. Learned Senior Counsel for the appellant applicants, Chief Chris Uche, SAN, leading other senior and other counsel, filed a written address in support of the motion. Upon receipt of the said motion on notice, the first respondent filed an 11-paragraph counter affidavit deposed by one Gift Mwadike, a legal secretary in the law firm of Diko and Mahmood, lead counsel to the first respondent. A written address in opposition to the said motion was also filed and signed by A.B. Mahmood SAN, lead counsel for the first respondent. For the second respondent, Senator Michael Okpeyemi Bamidele, a legal practitioner and long-standing associate of the second respondent, deposed to a counter affidavit of yet again 20 paragraphs on 12 October 2023. Annexed to the counter affidavit are exhibits 1 to 9. And in support of the counter affidavit and in opposition to the motion, Learned Senior Counsel for the second respondent, Chief Wole Olanipekun SAN, leading senior counsel and leading other counsel, filed a written address on the same date the counter affidavit was filed. The third respondent's counter affidavit was deposed to by one Peter Emma Iko, a legal executive in the law firm of Olujinmi and Akeredolu, lead counsel for the third respondent. The 9-paragraph counter affidavit is supported by a written address filed and signed by Chief Akin Olujinmi SAN. Upon receipt of the various counter affidavits, the appellants filed a further affidavit of 20 paragraphs deposed to by the same Uyi Giwa Osage, with 12 exhibits further annexed. Learned Senior Counsel also filed reply on points of law to the written addresses filed by the first, second, and third respondents in their opposition to the applicant's motion on notice for fresh evidence and or additional evidence. At the hearing of this motion, both the applicants and the respondents adopted their supporting and counter affidavits respectively. They also adopted and relied on their various written addresses. In the applicant's written address, the Learned Senior Counsel submitted one issue for determination, to wit, whether this Honorable Court ought to exercise its discretion in favor of the appellant applicants by granting the prayers sought. The first respondent's Senior Counsel also donated a sole issue for determination as follows: whether in view of the peculiar facts of this case, this Honorable Court can proceed to grant the instant application. For the second respondent, Chief Olanipekun SAN, submitted one issue, which states, considering the background of this case, as well as the applicable constitutional and statutory provisions relevant to election appeals and proceedings, whether this Honorable Court will grant this application. Finally, Chief Akin Olujinmi SAN, leading other counsel for the third respondent, opined that the crucial question to be addressed in this motion is whether this court has jurisdiction to entertain this application. Now, taking a clinical look at the four issues, it is crystal clear that they all say the same thing. And put in simple terms, it is whether the law of Nigeria, as presently constituted, allows this court to receive the evidence in question and act on it at this stage. In his argument, the learned senior counsel for the appellants submitted that this court has the power, the jurisdiction, and the discretion to grant an application to adduce fresh and or additional evidence on appeal, referring to Order 2, Rule 12.1 and 2, and Rules 12.1, 2, and 3 of the Supreme Court rules, and the case of Uzodinma and Izunaso, citation supplied, learned senior counsel submitted that the grant of this application will be in furtherance of the cause of justice. That this is a case in which the second respondent was purportedly declared as the winner of the election to the office of President of the Federal Republic of Nigeria, and the appellant applicants have, amongst other grounds, challenged the election of the second respondent on the ground that the second respondent presented a forged document to the Independent National Electoral Commission. That the appellants have also a challenge in their appeal, the striking out of their pleadings, raising the issue of qualification of the second respondent to contest the said election. Learned Silk also relied on the cases of Nigerian Customs Service Board and Innocent and other cases cited in this judgment. According to the Learned Silk, the evidence required to establish that the certificate presented by the second respondent to the first respondent in support of his qualification to contest the said election is the deposition from the Chicago State University, which deposition did not become available until after the determination of the case by the lower court. He contended that the appellant applicants have successfully explained the delay and difficulties in obtaining the said evidence earlier than now. Relying on Saleh and Abba citations supplied, the learned senior counsel urged this court to resolve the sole issue in favor of the appellants and grant the application. In response to the above argument, the learned senior counsel for the first respondent, A.B. Mahmoud Essay, submitted and urged this court to dismiss the appellant's application as they have failed to meet the conditions for grant of same. He opined that election petitions are sui generis, and as such, this court, in determining this application, must take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, and based on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the Electoral Act 2022. He stated the three conditions that has to be met before the fresh evidence can be admitted, and he urged this court to hold that the appellant's applicants failed to fulfill the conditions. In this, he relies on the case of Adeleke and Aserifa, Wata and Anyago, UBA PLC and BTL Industries, all citations supplied, amongst others. It is his contention that the appellants were tardy and were not reasonably diligent in their attempt at obtaining the documents which they seek to be received in these proceedings, that having not acted with reasonable diligence, this court ought not to grant the instant application, also relying on Obo and Enable S Limited. Oh my. Learned Senior Counsel also drew the attention of this court to the decision of the court below, which has not been appealed against, that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and that their efforts to remedy it through their replies to respondents' replies were belated and were rightly refused. According to him, the deposition of Caleb Westberg is irrelevant since the appellants did not raise the issue of forgery at the lower court. And relying on the case of Okwe Kenye and Registered Trustees of Jude Anglican Church, citation supplied is submitted that evidence not supported by pleadings goes to no issue. Learned Silk further submitted that insofar as the deposition of Caleb Westberg is solely to disdain the certificate presented by the second respondent and attached to his form EC9 dated 17 June 2022, which the first respondent published as far back as 24th day of June 2022, the appellant's complaint in that regard is pre-election matter, which by section 285(9) of the Constitution of the Federal Republic of Nigeria is statute barred. As such, an action ought to have been initiated within 14 days of the second respondent's submission of his form EC9 or the publication by the first respondent. He urged the court to so hold. According to Learned Senior Counsel, an allegation of presentation of false or fake certificate is rooted in the criminal offense of forgery, which requires proof beyond reasonable doubt. He contended that the deposition by Caleb Westberg, which seeks to establish a case of forgery against the second respondent without more, cannot ground a conviction for forgery of as proof beyond reasonable doubt cannot be solely based on an affidavit evidence, relying on Abubakar and INEC, Agi and PDP, Mohammed and Wamako, all citations supplied. Learned Silk argued further that the deposition of Caleb Westberg alone does not, under our law, constitute credible evidence to establish a case of forgery. Finally, the Learned Silk submitted that this appeal, being based on an election matter, where a trial court is to hear matters and deliver judgment not later than 180 days after the filing of the petition, the implication is that all evidence ought to be adduced at the trial court and judgment delivered within 180 days. That it was not the intention of the draftsman of the Constitution to allow and permit the receipt of evidence in an election matter when the court vested with the powers to receive evidence, has lost jurisdiction over the matter. He wondered what would happen now that all parties have filed and exchanged briefs with no arguments canvassed in respect of the additional evidence sought to be adduced in the instant appeal, there being no room to extend time under the pre-election and election appeals practice directions 2023 of the Supreme Court. He urged the court to dismiss the application. In his contribution, in opposition to the grant of this application, Learned Senior Counsel for the second respondent, Chief Olani Pekun S.A., submitted that this court is without the virus to consider the said deposition, either as oral or documentary evidence, more so when the evidence was not considered by the court of first instance within the 180 days time frame provided by the Constitution of the Federal Republic of Nigeria, relying on the recent case of Towo Womo and Ajayi, unreported, delivered on the 27th of January 2023 in this court hall. That the lower court, having lost its jurisdiction since 17 September 2023, upon expiration of the 180 days from the date of filing the petition by the appellant, this court cannot grant this application. That section 22 and 23 of the Supreme Court Act give power to order 2 Rule 12(1) of the rules of this court, and that can only happen if the lower court still has jurisdiction. Referring to Omubi Larry and Igbo Asoi, and others, and a deputy and a motion, all citations supplied, the learners contended that applicants failed to satisfy the 5 conditions enunciated in those cases before this type of application can be granted. According to the learned essay, the failure of the applicants to have validly pleaded facts and documents sought to be received in evidence is fatal to this application, relying also in Obasi and Omuka Start Oil, Nigeria Limited and Induction, and others, all citations supplied. Making reference to the USA Rules on Civil Procedure, 32A, 1A, the learned opined that the failure to invite the All Progressives Congress and the Independent National Electoral Commission to participate in the deposition made in the United States renders Exhibit C and D inadmissible. More so, since the alleged forged certificate is alleged to have been submitted to INEC. It is further contention that Exhibit C and D have no utility or affinity with this appeal for the fact that there is no ground of appeal upon which they can be structured, as well as there being no accommodative issue for determination, relying on a number of cases listed in this judgment. Finally, learned senior counsel submitted that Exhibit C, D, unpretentiously attempts to allege a criminal offense of forgery against the second respondent. You find that a criminal offense must be proved beyond reasonable doubt, as provided in Section 135 of the Evidence Act, also referring to the cases of ACN and Nyako and Kaki and PDP. He concluded that the Supreme Court does not have original jurisdiction to try the case of forgery. He urged this court to refuse this application and hold that it is an abuse of court process. For the third respondent, Chief Akin Olujimi SN made submissions which are similar to those by the learned counsel for the first and second respondents. With due respect to the learned Chief Silk, I shall refer to them in the process of resolving the sole issue in this application. In the applicant's reply on points of law, learned senior counsel listed some paragraphs of counter affidavit of the second respondent, which he alleges consists of legal arguments, objections, and conclusions, which he urged that they be struck out. On issue of jurisdiction, he submitted that Section 285(6) of the Constitution, which pegs 180 days for the hearing and determination of the election petitions, does not include the Court of Appeal, but only election tribunals. Learned Silk submitted that issue of qualification is for both pre- and post-election matters, referring to Section 137(1)J of the Constitution. He urged the court to grant this application in the interest of justice, as was done in Amechi and INEC and Obi and INEC, all citations supplied. In resolving the sole issue submitted for the determination of this motion, I wish to start from the beginning. And the beginning is the issue of jurisdiction. Whereas the respondents in their various written addresses have urged this court to grant not to grant this application as it is an exercise in futility. They opine that the Supreme Court does not have jurisdiction to look into or act on Exhibit C and D if admitted into the proceedings. The learned senior counsel for the appellants submitted otherwise. I have already summarized their various positions, and I shall refer to them as we proceed. It is elementary to state that the jurisdiction record is the authority which a court possesses to decide matters brought before it, or to take cognizance of matters presented in a formal way for its decision. In an old case of Ogun Makun and Milad Osun State, citation supplied, this court stated as follows: jurisdiction of the court is the basis, the foundation, and the live wire of access to court in adjudication under Nigerian civil process. As courts are set up under the Constitution, decrees, acts, laws, and edicts, they cloak the courts with the powers and jurisdiction of adjudication. If the Constitution, decrees, acts, laws, and edicts do not grant jurisdiction to a court or tribunal, the court and the parties cannot, by agreement, endow it with jurisdiction, as no matter how well intentioned and properly conducted the proceedings, once it is incompetent, it is a nullity and an exercise in futility. End of quote. The jurisdiction of a court has further been defined as the very fundamental and priceless community in the judicial process. That is to say, it is the fulcrum, the centerpiece, or the main pillar upon which the validity of any decision of any court stands, and around which other issues rotate. Thus, it cannot be assumed or implied. It cannot also be conferred by a party or by consent or acquiescence of parties. A lot of cases have been cited to support this. And that is the general nature of jurisdiction. I must emphasize that the matter under which the application is brought is an appeal in an election petition. It is tried that election petition proceedings are sui generis. It has its own set of laws and rules which a court must recognize and enforce. See Buhari and Yusuf, Egbarioba and Erobo, all citations supplied. In the circumstance of this case, this court, in determining this motion, has to take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, based on the provisions of the Constitution of the Federal Republic of Nigeria and the Electoral Act 2022. I have carefully perused page 1 of volume 1 of the Record of Appeal, and it is very clear that the petition giving birth to this appeal, and particularly this application, was filed on the 21st of March 2023, which was the last day of the 21 days prescribed in section 285 sub 5 of the Constitution of the Federal Republic of Nigeria 1999 as amended for filing of election petitions after announcement of result of election. By sub-paragraph 6 thereof, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition, and where there is an appeal, it shall be determined within 60 days from the date of delivery of judgment of the tribunal or court of appeal. As pointed out by learned senior counsel for the respondents, the 180 days prescribed for the hearing of the petition by the Court of Appeal lapsed on the 17th of September 2023. In other words, the court below lost its jurisdiction to determine any matter in relation to the petition. This application before us relates to fresh evidence obtained after the judgment of the lower court and after the 21 days for filing election petition and after the expiration of the 180 days of the filing of the petition. What are the legal and or constitutional implications of the above scenario in relation to exhibits A and D sought to be received into these proceedings? Several of the decisions of this court have taken care of the above scenario. One of the most recent cases decided by this court is the case of Towo, Womo, and Ajayi, the citation supplied there, wherein this court stated as follows, and I'll quote, In the circumstance of this case, this court cannot activate Section 22 of the Supreme Court Act 2004, since the 180 days provided by the Constitution to determine the appellant's claim at the trial court has lapsed since 1st January 2023. The originating summons was filed on the 5th of July 2022 and expired on 1st January 2023 at the Federal High Court. This appeal was taken on 2nd January 2023, and there is no opportunity for the contentious issues of fact in the controversy in this appeal to be sent back to the trial court. The issue of the merit of the allegations of false information was not tried by the two lower courts and cannot be tried by this court pursuant to Section 22 of the Supreme Court Act. This court cannot do what the trial court is no longer constitutionally permitted to do by virtue of Section 285 of the Constitution of the Federal Republic of Nigeria, the Groundnum. See OK, Mimiku, see APC and Marafa, all citations supplied. As stated by...
Sorry to pause it for a moment, but you could see Yemsen Wike there, sat with Ribado and the usual APC functionaries. But who is Yemsen Wike representing? That's the question. Who is Yemsen Wike representing as it sits with, what's it called? Certainly we saw Ribadu, and then we saw Bajabi Amila, and then we saw the chairman of the APC, but then we also saw Yemsen Wike, who continues to insist that he's a member still of the PDP, but there he is, sitting on the APC bench. So I just wanted to note that.
The appellant applicants in the application. The reliefs they seek is an order of this court granting them leave to produce, and for this court to receive fresh or additional evidence by way of deposition on oath. Clearly, the application runs foul of paragraphs 14 sub 2 and 16.1 of the first schedule to the Electoral Act, which inter alia outlaws any amendment of substance, as in this case, or introduction or addition of substance to the statement of facts relied on, not contained in the original election petition filed. Or 2, effecting a substantial alteration of the ground for or the prayer in the election petition. Or 3, except anything which may be done under subparagraph 2A2, effecting a substantial alteration of or addition to the statement of facts relied on to support the ground for or sustain the prayer in the election petition, end of quote. Nothing can be clearer than the above provision, which clearly states that a petitioner shall not be permitted to amend his petition after 21 days allowed by Section 132 sub 7 of the Electoral Act. The applicants herein have not even applied to this court to amend their petition in order to reflect the fact of forgery, and Exhibit C and D sought to be admitted into the proceedings. Facts and documents which were not pleaded in the petition have no place in deciding the dispute between the parties. I still wonder how the appellants intend to use those documents in this appeal. Let me consider an unusual submission of the learned senior counsel for the appellant's applicants. It is in respect of Section 285 sub 6 of the Constitution, which states, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition. But on page 3, paragraph 2.5 of the appellant's reply on points of law, he argued as follows, quote, interestingly, and contrary to the avowed position of the respondent, we make bold to submit that there is no such constitutional limit of 180 days on the lower court to hear and determine a presidential election petition, such that can rob this court to exercise its jurisdiction in any manner whatsoever. While establishing the election tribunals to deal with election matters from houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal, end of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of section 285 sub 6 of the said Constitution when sitting to hear election petition, just as other election tribunals, as was rightly submitted by the learned senior counsel for the third respondent, Chief Akin Olujimi SN, for which I wholly agree. The appellants knew they had to prove the allegation of non-qualification raised at paragraph 16D and 146 of their petition against the second respondent within the 180 days adjudication window provided in section 132 sub 8 of the Electoral Act 2022 for determination of petition by the lower court, which expired since 17 September 2023. The 180 days having expired, the lower court therefore no longer had jurisdiction to allow the deposition sought to be introduced into the trial of this petition. This is the law which at this stage is elementary. Consequently, since the lower court no longer has jurisdiction to entertain any such application, it follows ipso jure that this court, this Supreme Court, also has no jurisdiction to allow the deposition to be used in this appeal. It is settled law that where the time for doing a thing is limited by the Constitution or statute, the court cannot extend the time. That was the decision of this court in Brigadier General Mohammed Buba Mawar and Admiral Mortala Nyako, where Onogan JSC as it then was held as follows. Quote, it is settled law that the time fixed by the Constitution for the doing of anything cannot be extended. It is immutable. It is fixed like the Rock of Gibraltar. It cannot be extended, elongated, expanded, or stretched beyond what it states. See also Abubakar and Nassam, all citations supplied. It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petition. Let me say it clearly that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again Onogan JSC as it was in NNPP and GONI. Citation supplied when he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the lower court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of Section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original Section 285 of the 1999 Constitution, by allotting time within which to hear and determine election petition and appeals arising therefrom, is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also Uba and Suswan. Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit this position, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the determination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jackson, 2002, for Nigeria.
Oh, okay. Apologies. I was intending not to stop it at all, but what that judge just said, that justice just said there, Justice Okoro, that essentially ends matters right there. So they are not admitting Atiku Abubakar's adventures to Chicago for reasons that for reasons that he just adduced. So if they are not admitting the CSU phase, the CSU excursion, if they are not admitting that as part of this case, then nothing varies then from what happened at the appeal court, because that's the only new twist. That's the only new twist to anything since the appeal court. So if they're not admitting that, then there is no variation to everything that was adjudicated at the appeal court. So that is really why we have quickly come to this decision. And a lot of people said they are rushing it through. But if they made the decision not to admit the CSU for all of the legal reasons that they've just stated, then nothing has changed from what the appeal court ruled. So, and they had, well, let's just hear it, but you can already see where this is going to land.
Will report. Citations, others supplied. This court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal, as this court cannot exercise original jurisdiction, even if we are to start a new case for the appellants. C. Sanusi and Ayula, Gtex Industries, and Oceanic Bank citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court, which include, that's all right, but not limited to Owu, Buariri and others, and Igbo, Oyosi and others, Supra. Adegbite and a motion are cases cited by the Senior Counsel by the second respondent. Simply put, the conditions for the grant of this type of application are that 1, the fresh evidence could not have been obtained with reasonable diligence at the trial. 2, such evidence, if admitted, would have important effect on the subject of the appeal. 3, such evidence ex facie is apparently capable of being believed. 4, such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5, and if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said deposition sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned Senior Counsel for the first respondent, A.B. Mahmoud Essay, the presidential election was conducted on the 25th of February, 2023. And the first respondent declared the second respondent as winner of the election on 1st March, 2023. Thereafter, the appellants filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondents from EC9 and accompanying documents in June 2022, a year more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the documents from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial? To say the least, the above questions are critical in the quest of this court's efforts to decide whether the new evidence sought to be adduced could have been obtained by the appellants with reasonable diligence for use at the trial. And with due respect to the appellants and their counsel, I think they were a bit tardy and were not reasonably diligent in their attempts at obtaining the documents which they seek to have this court receive in this appeal. In Adeleke Aserifa Supra, this court held that where the evidence is available and could with reasonable care and diligence be made available to the applicant at the time of the trial, as in this case, the court should refuse to exercise its discretion to receive such evidence. From all I have stated above, it is crystal clear that the additional evidence by way of the deposition of oath does not fit into the issues submitted for the determination of this appeal. The application, my lord, of the appellant applicants in the circumstance is hereby refused and accordingly dismissed. I now go to the main appeal. I want to say that the motions filed by the respondents to challenge some issues, grounds of appeal, we have decided to ignore them, strike them out, and hear the appeal on the merits. The learned senior counsel for the appellants distilled 7 issues for determination, all of them, except the last one, the third respondent submitted 6 issues. So we have stated all there are 7 issues in the judgment. You will see them when you get copies. There is no doubt that all the issues submitted by all the parties are similar, and any could be adopted for guidance. I propose, however, to determine this appeal based on the issues as formulated by the appellants. After all, it is their own appeal. Issue 1. The thrust of issue 1 is whether the lower court was right in refusing to hold that the failure of the first respondent to electronically transmit results from polling units nationwide for the collation of results introduced by the Electoral Act 2022 and specified in the regulations and guidelines for the conduct of elections 2022 and manual for election officials 2023 does not amount to non-compliance, which substantially affected the outcome of the election. Chief Krisuche, SA, learned senior counsel for the appellants, submitted in the main that by virtue of Section 64, Sub 4 of the Electoral Act 2022, the collation officers and returning officers of the first respondent, including the national chairman of the first respondent, were under a statutory obligation towards mandatory verifications and confirmations at all stages required before the announcement of the result of the election. Learned Silk further contended that at the trial of the appellant's subpoenaed witnesses, several and presiding officers, including PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who handled the BVAS machines at the polling units on the election day, who confirmed the non-transmission of results of the presidential election electronically from the BVAS machines, whereas the results for the National Assembly election held simultaneously were electronically transmitted without difficulty. That the appellant's witnesses gave evidence that the bypass of the use of the prescribed verification technology was nationwide, affecting the entire polling units and collation of results all over Nigeria, and substantially affected the outcome of the election. That the sole witness of the first respondent, Lawrence Biode, admitted under cross-examination that the deployment of the technology of BVAS and IRev was to guarantee the transparency of the electoral process and the integrity of the results, but claimed that there was a technical glitch that made the system fail to work on the election day, which technical glitch was not explained by the first respondent. The appellant contended that the failure to transmit the result electronically led to manipulation of the results in favor of the second respondent. Learned Silk then urged this court to depart from its previous decisions pursuant to Order 6 Rule 54 of the Supreme Court rules on the manner of proof of non-compliance with the provisions of the Electoral Act in the light of the novel provision in Section 132 of the Act and paragraph 46 of 4 of the first schedule to the Electoral Act. The learned SAN submitted that the assurances given to the public by the first respondent as a public institution that results will be electronically transmitted was dashed. It is his contention that the election ought to be nullified by reason of the gross misrepresentation by the first respondent based on the doctrine of legitimate expectation as applied by this court in Stitch and AG Federation. Citation supplied. The learned Silk concluded on this issue that given the introduction of technology into the collation process by the new Electoral Act 2022, the judicial approach and attitude must of necessity be different from the analog past. He then advised this court to depart from its decisions on mode of proof of non-compliance with the Electoral Act in election petitions, as was the case in Nyesom Wike and Peterside, Okereke and Umahi, Shinkafi and Yari, amongst others. He urged the court to resolve this issue in favor of the appellants. In response, the learned senior counsel for the first respondent, A.B. Mahmoud Hussein, urged this court to decline the invitation to override its previous decisions on the manner of proof of non-compliance because such invitation is not usually taken lightly by this court. He contended that the conditions for such application does not exist in this appeal, relying on VP Industries Limited and Cocoa Industries Limited citations supplied. He contended that the appellant has not contended that the previous decisions sought to be departed from were given per incuriam or erroneous in law. On the argument that first respondent failed to electronically transmit results, he submitted that the only reference to electronic transmission of polling unit results appears in paragraph 38(1) of the guidelines published by INEC for the conduct of the election, wherein it provides that presiding officers shall electronically transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IRev portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IRev portal is only a public viewing portal and not a collation portal. Relying on Oyetola and INEC. points irresistibly to a manual collation of results, contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulation, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned counsel Olanik Bekun urged this court. Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peter's side, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Leonard, any agreements for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses, many of whom were incompetent witnesses, while purporting to prove allegation of non-compliance, covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate evidence, the allegation of non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar, and INEC, all citations supplied. He urged the court to resolve this issue against the appellants. In their reply brief, the learned senior counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46 or 4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act. That these new provisions deal with the new manner of transmission of result as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By section 135, sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the act and that the non-compliance did not affect substantially the result of the election. From the provisions of the act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real time to the IRev portal. According to the appellant, this was enough to nullify the election of the second respondent. What exactly is the IRev portal? The court below held that the IRev portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IRev portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collated at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IRev portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IRev deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collected with the ones transmitted into the IRev. Truth must be told, the non-functioning of the IRev may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IRev is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IRev portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the commission to the following in the order below. 1, the Nigeria Police Force, and 2, agents of political parties. End of quote. Paragraph 93 of the first respondent's guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IRev portal does not exist, the commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IRev portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IRev portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My Lord, having failed to prove documents and entered the evidence, it is to be shown that they manifestly disclosed the non-compliance. The result of the election
Sorry, the audio quality is what is coming through from the feed. It's nothing to do with our transmission here.
The learned senior
It's
counsel
back.
for the appellants urged this court to interpret the word "and" in section 134 2b of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in section 299 of the Constitution for the purposes of fulfilling the requirements of section 134 sub 2b of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did." End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving some a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution, or any statute for that matter, a narrow and selfish approach, the duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is trite that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The POSA rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellant subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27 and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedural Rules 2019 is not applicable in election matters. Learned Senior Counsel for the Appellants falls the decision of the court below for relying on paragraph 4 of the first schedule to the Electoral Act, failure to apply the provision in Order 3, Rule 2 and 3 of the Federal High Court Civil Procedural Rules. He submitted that the interpretation given to paragraph 4.5b of the first schedule to the Electoral Act 2022 by the lower court in disallowing the testimonies of the appellant's subpoenaed witnesses will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the three senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 4.5b of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedural rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285, sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 4.5 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses in election petition proceedings is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bits, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in Oke and Mimiko, citation supplied. In his contributory judgment in the above case, Clara Ogumbiyi JS retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt,
which provides for extension of time. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 134 Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation, seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4.1 and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citation supplied, this court held that application of time to call additional and file additional witnesses' statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citation supplied. Compel the impossibility, and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned respondent, A.B. Mahmoud SN, subpoenas and the effect and purpose of 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4.5 of the first schedule to the Electoral Act 2022. It is on this note that I hold that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' collation agents at the court below. The appellants are aggrieved by the verdict of the court that witnesses a hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC citation supplied, this court, per agim JCA, as it then was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, PW1 was not a polling agent. He was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners. They agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or principal, having regard to the fact that no mortal can be in all the places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the collation agents in this instant case, who are PW 1, 2, 5, and 2 and 7, relating to suppression of votes, multiple thumb printing of ballot papers, entering of wrong scores results, disruption of voting, are inadmissible hearsay and are hereby discounted as end of quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Jimobi, and others cited. From the evidence on record, it is indisputable that PW 1, 2, 3, 5, and 7, who were the appellant state collation agents and national collation agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence analysis of PW 1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to wit, Messrs. Adejo and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4 sub 1b of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their averments were sufficiently detailed. They also question the decision of the court, striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present the election petition, 3, state the holding of the election, the scores of the candidates, and the person returned as the winner of the election, and 4, state clearly the facts of the petition and the ground or grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above, is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading, that where an averment is not supported by evidence, the averment is deemed abandoned. For, in keeping with the audi alteram partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Econife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, are not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16, sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondent who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. there is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners. That the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134, sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than two candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-a-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citation supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the results put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties, and probably their counsel, should refrain from media trial and media judgments. I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment. Thank you.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed. And I also did not make any order as to cause, but affirm the judgment of the lower court, declaring the second respondent, Bola Ahmed Tinubu, as the duly elected President of the Federal Republic of Nigeria in the election of the 25th of February, 2023. Thank you.
My learned brother to my immediate left will deliver his judgment.
The lead judgment just delivered by my learned brother Okoro Jersey has comprehensively presented all the points I made and the views I expressed at the conference of the honorable justices of this panel over the appeal. He has very proficiently presented all the views which I express in respect of all the issues in both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself. But I would like to say that the point raised by the learned senior counsel for the appellant, Chief Chris Uchezian, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting, attractive, but when taken along with the relevant provisions of the Constitution, as well as the Electoral Act 2022, it, with respect to Chief Uche Ezean, spacious. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named presidential election petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it's coming up, and it is good that this court will make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. it is for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite reasoning and conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course, because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Ian Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSC.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Inya Okoro, JSC CFR. I completely agree with the reasoning, conclusions, decisions, and others therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views. That the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed her certificate of reporter, bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court because of the peculiar circumstances of this case and adopted as a deposition ordered to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku Abubakar for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the district court or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said district court or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the state U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part, that the words can truly support the wordings used in that provision. That is how to read a constitution. Yet remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal. I call the next one.
SCCV 937-2023. Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC Respondents.
Appearances.
The Lordship, my name is P.I.N. Ikweto. My lords, unfortunately, we have a type list of counsel. And by the time my colleagues brought it to the registry, they were told it was late. If the Lordship allow me, can I submit that list?
Please, sir, submit it.
Thank you, my lord, sir. And my lords, with respect,
judgment day, you don't go late to court.
I was here before. I was there by 8 o'clock, sir.
So that you won't be late when God will be giving judgment.
Oh, my lord, on the day of my own judgment before the Lord, I will be there alone. So I will never be late there.
So,
and I'm sure you will accept me when I get there, sir.
God will accept you.
I'm sure you will.
I pray it should be so.
Amen, sir. My lord, I want to say that my name is P.I.N. Ikweto.
So, sorry, I have to say that was a cute little exchange between that lawyer and the judge.
I love it, one man. I love it.
That guy has a sharp brain.
I know.
He didn't know that was coming. He threw it at him. He picked it up and threw it back. The judge threw it back and he landed it. So
he landed it. Yeah,
that was quite cute.
Amazing.
Yeah, that was quite cute. So that was Atiku sent back to Abu Dhabi to go and continue to be the Waziri of Abu Dhabi. So now let's listen to Peter Obi say to let them send him back to Oka to go and be the president of the Rotary Club. Rotary Club Oka. Yeah, look at these silly people. Yeah, idiots.
Come on. Man.
Let's get back.
Yeah.
And your lordship, with respect, we have in line with your lordship.
I think we should start calling you Saint Ikweto.
No, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
I don't please. I don't know where we can discuss that, sir. My lord, we've taken the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my lords, Alex Ejesieme, S-A-N.
Azinga.
Yes, sir. Azinga is number 3, sir.
Yes.
Number 4, my lord, is LX AJCMA S-A-N.
Where is Azinga?
My lord, Azinga is just beside me here. She's been here all morning with me.
Azinga used to be black. I don't know why she's white today.
No, she's always been fair complexion. Always. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a lot of places, yes, sir. She's been fair complexion.
Is that judge accusing the lady of doing Carol White? Remember when they said
Carol White, yeah.
Remember when they said that to be
What's going on here, one man?
Look at that. She used to be black, now she's yellow. What happened there?
Body Cokie, Oju Coca-Cola.
Let's get back.
No, all along.
It's okay. You're welcome.
Yes, my lord.
Leonard SN Equator, did you say Valerie is number 3?
My lord, on the list, she's number 3.
But she's number 2.
She's number 2, yes, sir. Yes, sir. I just want to make it easier for my lord, sir. The next, my lord, is Mr. LX AJCMA S-A-N.
Yes. Chike.
My lord, as a Chike A.O.B. Esquire.
Yes.
And my lord, lastly, and in compliance with my lord's directives, AGO4 Onwaso Esquire. The lordship, the appearance with due respect is for the appellant in this appeal.
Isn't it, Thomas, isn't it a curiosity that the entirety of the Obi narrative is Igbo, but they are fighting for Nigeria? Did you not see? We've said this often enough, and it continues to recur.
Now now. One man, you know now.
But they are fighting for Nigeria, and it's not tribal or ethnic, but
no.
The whole narrative is Igbo, and the whole of their team, their legal team is Igbo, but it's about Nigeria.
It's about Nigeria, yeah.
Hey, look at that. Funny people.
Yes.
Yes. Please, my lords. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my lord.
Stephen
Adehi, my lord. Okay. Sir Stephen Adehi.
Leave that thing. Adehi.
Yes, my lord.
So sorry, Thomas. Did you hear the justice just say, leave that thing?
I heard it. Yeah.
Yeah, I heard it. I told you the mood of the Supreme Court.
When did the Queen knight him that he became star? He said, "Don't come here." He wants to put on air and graces. This as it is just. I don't want to go too ethnic, but it's just
One man.
And this is the issue, isn't it?
One man. Have you noticed what we've been saying about Supreme Court? They have no time for silliness. Can you notice now?
Look at that. I am Sir Lord Mayor Alhaji Chief Doctor Professor. Leave that
Oluwo.
One man, fast it forward. We are a little bit delay. Fast, take the video forward.
Let me take it to where it's most current. Okay.
Correct. Yeah.
Let's take it from here.
Not number 10, my lords. Thank you very much, my lords.
1, 2, 3. Amira. Amisu. Yes.
If it pleases my noble lords, my name is Akintola Makinde, and I appear with my colleague, Okpe Moritala. Your lordships, we submitted a typewritten list in the morning, Very respectfully, our appearance is for the second and third respondents. We are very grateful, sir. Okpe Moritala, my lord, is number 2 on the list here.
Yes.
We are very grateful, sir.
Yes. Yes.
Respondent.
Yes.
Appear with me, I'm learned friends. My lord, I'm sorry, the next name is not on the printed list which is submitted.
Let me, okay, here.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi.
Thomas, just for balance, everybody has gone ethnic. All the teams, they've gone ethnic.
How much obliged, my lord?
Yeah, yes, now. I think everybody's going to that route.
Respectfully, my lord.
Mama, they are big gods.
Yes, they are big gods.
They are maggots. Not only big gods, they are maggots. One man, why can't they just join their both sentence, join it together? No wasting of time. All this nonsense.
Yes, I think that's actually what the judges are trying to do. They're trying to speed it through. You know, they've already written their judgment, so they're just going to give us the highlights, send them back home, Atiku back to Abu Dhabi, Peter will be back to the Rotary Club in Oka, where he can go and be their president there. And then the rest of you can go and be making your noise on the internet, but you know.
The lady just said, I'm sure that this will not last 12 hours. You know that they are not wasting time. They are not wasting time.
You know, because the appeal court has already done all of the work. So it's either just they agree, all they have to do is say, I agree with what the appeal court said, I agree with, and that's
yes.
I think they're back
in
now.
This appeal, we have, during conference, noticed that issues number 1, 2, 3, 5, 6, and 7 in this appeal have been dealt with in Atiku's appeal. It is the decision of this court that this issue shall abide the outcome of the issues as resolved in Atiku's appeal, mutatis mutandis. As for issue number 4,
do you see what we just said?
Which has to do with double nomination, which was not in Atiku's appeal.
Only now.
It is the view of this
now
court.
they've joined them together.
This issue
so they will not read
about
about Obi anymore.
In S6 to CB, to 501 to 23, which judgment was delivered on the 26th of May 2023. This court cannot allow the matter to be relitigated in this very court. There must be an end to litigation. For us to sit down now and talk about when this man resigned or did not resign, when they did a fresh conference or fresh primaries to replace him, which we have done before. We are not going to do it again. This matter ought not to have come here. When the matter was pending at the trial court, this court delivered that judgment. If you read the judgment of the lower court, they mentioned it, that Supreme Court has settled this matter. And that should have been the end. You now bring this issue of double nomination for us to sit on it and write another judgment. This is not how it should be. This appeal lacks merit and is hereby dismissed. My lord, to my right, Abaji.
I agree with my learned brother, Justice John Ian Okoro, that this appeal, number SCCV 937, 2023, Mr. Peter Gregory Obi and the Independent National Electoral Commission lacks merit, and it is also dismissed by me.
My lord, Garba Jesse.
I also totally agree with the lead judgment that this appeal substantially canvas the same issues with the appeal number
One man, are you sure we are not the one that wrote this judgment for this
very
judge?
comprehensively
No,
dealt
the
with?
judgment wrote itself now.
And
There's an
there's no need for us to repeat ourselves
Because
the issues
there
are
is
the
nothing
same.
they are saying now we haven't said
The
on
only
this
issue
platform.
that's different, like pointed out by
It's Ogbeni that
the
wrote
PG,
the
is that about double nomination, which you have settled, and we do not intend to reopen it again in this appeal. On the whole, I also join the lead judgment to dismiss this appeal for lacking in merit.
My lord, Salah.
Having had the privilege before now of reading a draft, the judgment
Can you
prepared
sit down?
and
You're
delivered by
already
my late
making
brother.
fun of them in the side. This guy
How
is
do making fun of them already?
I cannot but
Let me
concur
say,
with the
now.
far-reaching reasoning and the conclusion that has been postulated in the judgment to the effect that the instant appeal lacks merit, thus ought to be dismissed by this court. Having associated myself with that reasoning and the conclusion, I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
My lord, Jauru.
Well, I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother, John Ian Okoro, JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is devoid of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My lord Abubakar Jesse.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro, JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My lord Agim Jesse.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rest.
Want to party a job?
Ó ti bẹ̀ o. Ó ti bẹ̀ o. Baba Bola, mi ò ráyè. They don't get.
Oh, ráyè.
So I told you guys yesterday, the Supreme Court
Enigmatic
justices.
Suni Klode.
Baba,
Let me ask you a question. Let me ask you a question.
Yeah.
When you go to the cinema and watch a very interesting movie, However interesting that movie is, when it comes to the end, what's the last?
The end. The end in the cinema. The end in the But one man, hold on. They didn't read anything about Obi now.
No, they read it now. They said the appellant is not. They said the appellant is not useful to them in the court, and they said that's their conclusion. It means Obi is not useful to them. Did you not listen to that?
Say one fine one, say one fine one.
One fine one now. Enigmatic.
One fine.
No, it's not. It's not expressive. Each of them will be responsible for their.
Everybody should bear their causes.
No, I thought Justice Okoro awarded costs.
No, I didn't hear that.
I didn't hear, but what I heard was each of the parties will be responsible for their cost. That's what I heard.
For their cost. Yeah, that's what I heard. Yeah,
that was what they said.
This is a miscarriage of justice, one man. I think they should have fined them maybe 2 billion naira out of their money.
Enigmatic. They didn't read anything about Obi. They just can't dismiss him.
Well, I told you already. Thomas, look, Obi is a product of the judiciary, right? He was a Supreme Court governor, but he came to national TV to call them cultists, and he's been lampooning them. He's been instigating, his headless mob against them. So they don't have issues with him again. That's why they say it's not useful to them. They said appellant is not useful to us in this court, and they just within 5 minutes they close his case and they stood
So it's a unanimous decision.
Yeah,
they dismiss him
7-0. 7-0. 7-0.
I mean, is this not what we have been saying?
That's what I was actually looking to see. So let's hear Gbajabiamila Miller. Let's hear. Do we want to hear Gbajabiamila Miller?
Yes, let's hear Gbaja.
Let's hear him.
Let's hear him. Yeah.
Bring him.
I have little to do.
Like the judge said, all litigation must come to an end. They addressed all the issues, about 7 of them, and those issues were, and the judgments on each of the issues were clearly unassailable as far as I'm concerned. So for me now is the time for us all, every Nigerian, particularly the president, to roll up his sleeves and continue with governance. This has been a distraction. The litigants exercise their rights to go to court, but that has come to an end now. We now have to all come together as one country, one people, and move ahead and take this country where it rightfully should be. We're happy. We're excited.
So coming together, does
yes.
that mean that you'll be extending a hand to the PDP and the Labour Party? Although the APM's appeal was dismissed, but would the president be extending a hand of friendship or partnership to the other political parties?
Well, listen, we shouldn't take these things personal, right? If you listen carefully to the judgment was very sound. By any objective, right-thinking person, supported with facts, with cases, with statute. The president, if you know him very well, is a Democrat. It's not now that he's extending his hands of fellowship. He's always done that. He will continue to do that, and will continue to do so on his behalf. Governance is about everybody. It's not about a party. It's not about an individual. And if we do not come together now, then we'll have ourselves to blame. Opposition is not, you don't oppose for the sake of opposition. Elections are over, litigation is over. All litigation must come to an end. Now is the time for governance. Distractions over. So yes, Mr. President, the APC, and all rightful thinking members of the society must come together, no matter what party you belong to address the issue of governance.
Thank you very much.
Thank you very much.
Sir. Excellent, sir.
Okay. Well, I want to first give all the glory to Almighty God for this judgment. It is indeed another day that the Lord has made. We're glad that this puts an end to all litigation and a closure to all the speculations and all that. Mr. President, in his magnanimity, I'm sure will now begin reach out to all to join hands with him in his renewed hope agenda. APC was his platform, but the Nigerian state is where he's president of. So this is not just a victory for our party APC, it's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the Appeal Court. Their judgment was very detailed, it was very meticulous. It laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. It was straight to the point. And I believe that this judgment would be seen worldwide as that which is in line with global best practices in law. I want to salute them again because, you know, they are the bastion of hope for everybody, including the common man. And this is a victory for democracy. Opposition.
All right. I'm not sure that Dakwa Abiodun has ever had anything of any importance to say, but let's just start taking reactions. Ajanleko will kick it off. So there it is right there. So now they've had their fun, Ajanleko, and they have had their fun for 12 months, whatever. But now the matters have been settled now. Anybody that now still act out of tune, Koboko, or what do you say, Ajanleko?
Yeah, greetings to our listeners around the world. Click on the like button, share, and subscribe if you haven't done so. Enigmatic, I think you live next to Rational Mind. Can you go and wake him up? Wake him up to come and see what it is.
Rational Mind, Rational Mind slept under the influence of Cameron last week.
You want to hear Wiki? Tell me if you want to hear Wiki.
Yeah, let's hear Wiki. Let's hear Wiki. Let's hear Wiki.
Because Wiki, it would make more sense than Dakwa Abiodun.
The FCT has no special status. As the minister of the FCT,
Maybe
the court today said
states across the length and breadth of the world. Once again, I congratulate President Bola Ahmed Tinubu for this victory, and I congratulate APC. I congratulate Nigeria. Thank you very much for having me. Thank you.
Yes, just one question.
Okay, what is it? Yes.
The court today said the FCT has no special status. As the minister of the FCT,
maybe you don't understand what he said. FCT has no special status. What he said that in terms of calculating or having the special square, you must not win FCT before you are declared president of the Federal Republic of Nigeria. That FCT is like another state. So that you don't need to say, oh, if you don't win FCT, therefore you cannot be declared. That's what he said.
So you must have this start with the APC, how many players said that you have moved?
So that settles that matter once and for all. We are never, ever in the history of Nigerian politics going to ever revisit that FCT narrative again. But let Wike conclude, and then Ajanle Koko pick it up.
I didn't come with APC crew. And in the court here, in the court here, I don't know where they said APC and PDP. I came here as somebody who's interested, as somebody who wanted the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. So that Mr. President can focus and do what he's supposed to do for Nigerians. Thank you.
Election litigation and the delay it tends to constitute election litigation and the delay seems to constitute distraction.
Mama, let's continue.
Well, you see,
No, like that. I like to go there.
well, you see, this is a
a
developing democracy in a developing nation, so you expect such distractions to occur. But I believe we fine-tune our laws, especially electoral laws, and and we believe we shall come to the mature stage that we are expecting. Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use this opportunity to congratulate politicians, to congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so, rather than taking, arms against against each other. Yeah. So we have to congratulate our politicians for resulting to judiciary, and the judiciary has done well. It means that democracy is getting matured in Nigeria, and we are happy with that.
One man, just for the record, it took the honorable justices 120 seconds, just 120 seconds to dismiss Peter Obi's matter.
Yeah, but why did it take them that long? Is more the question. Why did it take them that long?
But one man, let's be honest, they didn't regard Peter Obi. They even regarded Atiku. They just dismiss him. It's just.
The Peter Obi narrative ended with the Soyinka interview. When it just gave that understanding that it's Bajue. I think that is when they give that understanding that it's Bajue, that ended it right there. But Ajale Koko, so there it is. Any more noise making now, Ajale Koko? Do you expect the state to assert the fullness of the weight of the state, or do you still expect them to be accommodating all this noise making that we have had to endure for nearly 12 months? Ajale Koko.
Look, Maman, yes, this matter has come to an end, and the justices have made it clear in their conclusion that the petition lack merit. I think we should underline that statement, that conclusion. It lack merit. On that basis, they dismiss. They voted against it. It lack merit. And now that we are where we are now, it is clear to everybody that it lack merit. On that basis, they affirmed the president as the winner. I want to see Abubakar Atiku, before the end of the day, to come out as a promise that he will abide by the decision or by the ruling of Supreme Court. If it does not go his way, he will show respect to that decision. We are looking for him to come and make statement in that regard. And Obi as well, who said before or at the beginning of this matter, when he filed his petition, that he believed in the judiciary to show that he is a man that can be trusted, to come and make statement and abide by the decision. This is what will tell us about them, that yes, they believe in the system, they contested to govern, and then we can move forward. And they should speak to their followers, their party, in a very clear time that yes, they and congratulate the president, so that everybody around the country, all their followers, all their party members, can see it that, yes, it is time to concentrate on the governance and see where they can monitor the president governance style and see where they're going to criticize him objectively in the best interest of Nigeria, so that we can all together join hand to rescue that country. It is not the president that really matter now, or APC, but Nigeria. We must all save Nigeria. They must not rest. They must stand up and see where they can help the president if necessary. If necessary, they should join hand with him and see how they can save that country, because that country is not in good shape at the moment. The state of the nation it's require everybody to come together and save the country in the best of us that are living today and the coming generation. So this is what I'm expecting from them. Let me leave it there, one man.
One man, before you move forward, can you take away the channel something?
If you can link and write news, if you can link and nice news, and we can be
let me
watching
link
it in
right. Let me. I just want something there as a back, just to frame the conversation.
To
So
frame the. Oh yeah, that's all right. That's all right. Yeah.
I can go to a writing news as
But one man, are you sure Ogbeni Enigmatic did not write this judgment?
I suspect that Enigmatic wrote it. Or Enigmatic, actually at it too. Actually at it too. But
you know,
Enigmatic, respond to that, but pick it up from this as well. The pressure now goes to Atiku Abubakar and more Peter Obi. But do you now have the anticipation that this is an opportunity for Peter Obi to, for the first time in known history, show that he's a statesman? So are you expecting a statesman-like response, especially from Peter Obi? Because there's somewhat a possibility that Atiku will be statesman-like, but are you expecting a statesman-like response from Peter Obi, or is he going to double down into that cesspool of that rabbit hole that is been burrowing into for the past few months? So what sort of level of response are you expecting from P to Obi?
Well, I won't even want to dignify him too much of my time, just like the Supreme Court spent 120 minutes to get him out of their sight very quick. What I would say, I think I've said everything last night. If you could recall, one man, I said everything clearly. What is going to be the beginning of the end of his political sojourn in Nigeria? He has actually shot himself in the foot this electoral period. He had a very good fight. He had a very good run, but he mismanaged, his political widow's mite. Now he has demonstrated that he lacks the character, of that mythomanic, personality that he actually wants to, project to everybody. And it's so clear to everybody now, the reasonable ones, though, who can see by his conduct so far. I'm going to be surprised if he does actually, demonstrate what you are trying to say now. That he's probably going to be, because he jarred. Let me use your English. He jarred everybody up, especially people who can reason very well. With that is a sabic remark against the judiciary and the personalities and the institution of the Supreme Court, calling them cultists.
Cultist, my brother,
Yeah.
cultist.
So that alone, that one man, lawyers are so stubborn, right? Lawyers are stubborn as rock. The moment they see that you are trying to intimidate them, then just it means you've drawn the line for them, and you can never win against them when it comes to that agidi level. Then their stubbornness is just 1/10 of the stubbornness, right? And the erudite arrogance of the justices of Supreme Court. There's a reason why they call them oracle of the law, and there's a reason they call them the ancestors in the legal temple. You cannot intimidate them. When they see that in you, they will do everything in their power to do the needful, right? To bring you to your level. Prior to the appellate ruling the other day, 5 days or a week before then, the Honorable Justice Mary Odili came out to make a cameo comment, right? And he specifically focused on Peter Obi, because if you are very conversant, you will know that lady was instrumental, played a very vital role, in Obi's judicial victory in the past. And if such a lady who was at the time, right, carried him at her back to the judiciary to ensure that he had the eyes of the law, so to say, and then came out like that, vociferously trying to call you out, giving you the signal that you need to stop instigating the judiciary. He has been, in a proxy manner, right, instigating these headless mobs from day one. He never calls them to order. When you try to call them to order, he finds a way to always defend them, until finally that he has come out to say, okay, to show his hand that he is in full support of their arrogance and the truculent manner in which they've conducted themselves against the Nigerian institution. So now, to conclusively go to your question, I will be surprised if I see him do the needful, which is expected of him, right? Pretending to be a statesman, pretending to be a leader, and then pretending to be, that saint that his people always want to project him to be. I'm going to really be surprised for that, because I will expect him to find a way to keep the headless mob, to keep that, that is base. And for you to keep the base, you have to go the Trump way, always doing the opposite, acting in contrast to reasonable projections of any reasonable human being. So if he does that, then it means there will be a clear demarcation now going forward from his core base. And does he actually want to lose those core base? Because the core base, they feed on chaos, right? One man, and he needs to feed them. He needs to continuously and continually, right, energize them with that chaotic narrative that they want, and that will end it there. His brother, his kinsman from Anambra State, right, clairvoyantly, he has actually stated this ab initio. That is Soludo. Sir?
Sorry. One man, I hope you won't mind. Let us listen to these people. What are they saying? Maybe
Okay,
a little
yeah.
bit.
Do you want us to listen to? Because I especially like that that Shobo Ali man. He always speaks sense.
Yeah, Mama, let's listen to them. Yeah.
Yeah, go ahead, one
check.
man.
No, gave assurances that it will transmit the result real time. The regulator of the election has the discretion to do what it likes with the rules. Get me? So the moment INEC has submitted that, it doesn't have to download immediately.
Mr. Shibon, I'm so sorry to interrupt, but of course you'll get a chance to finish.
Okay,
Please
then.
hold the thought, because we do have to cross live to Abuja right now to see what's going on after the Supreme Court has affirmed President Tinubu.
Credible means believable. Why shut out the people for the right the law has given unto them? So I was very glad that the Supreme Court pointed it out, that non-uploading of the result reduced the confidence of Nigerians in it, meaning that it cannot be presumed to be credible because Nigerians were shut out in it. So I loved that particular part. Thank you.
Mr. Shiboy, that was raised now that it reduced the confidence.
No, I don't know. I don't think that has reduced the confidence of Nigerians. Maybe you don't listen to me. What I was saying was that in defending how it conducted the election, INEC, you see, we all thought the election, I mean, the result will be downloaded electronically, just like that. But in his submission, he said it's not duty bound, you get me, to download the results electronically before announcing it, or announcing it before downloading it electronically, which was what he did. And then a court of appeal had ruled earlier on a case that the regulator of the election has the discretion to interpret the Electoral Act as it is convenient for it, which is what really happened, and which is what the appeal court for the presidential election, which is what they upheld. So it is not strange to me. And then on the issue of Abuja, as on the fifth state, you see, the Court of Appeal judge went into the memorandum of association preceding the election. And he said, look, the spirit of the Constitution is there. That you cannot say, because somebody has not won in one federal capital territory, even if you have won the majority of the seats in the 36 states, you say you cannot win an election. That is not, it's not logical. So I respect the reasoning behind the decisions of the courts, not wasting time in putting an end to litigation and allowing us to continue with our political life. It's a good development. Thank God nobody can appeal again. So we have governance for 4 years. And I'm happy with that.
We certainly hear it, but Mr. Finney, I'm wondering, based on what was stated, like IRev and the FCT 25%, do you think we're going to need to see the need for more clarity as we move forward with our democratic process for subsequent elections?
Well, the issue of the 25% of votes, I think is very clear. And because the appeal court sitting as the presidential election petition tribunal dilated seriously on that. And I think the Supreme Court wholly adopting that position had put to rest the issue of Abuja and 25%. There's no argument about that anymore. Yeah. But the issue of
shall we mute this
what
for
you
a
said,
moment
INEC can interpret the law. I don't think that's
if
what
anybody, if they're saying anything particularly striking, then we can pause it.
Yeah, one man. Yeah, let's do that.
Because the law did not state expressly that
Let me conclude on my
Enigmatic conclude. Enigmatic, before you conclude, the judges, they put out something there. The man said we have to stop litigation. They were just referring to the previous judgment that has been laid down on even this double nomination. I can see the frustration in that Judge Okoro's voice, that why are you bringing this case again to us? It's just, continue, my brother. It's just
Atiku has also built their reaction and what is expected of them. Look, Thomas, the Supreme Court is not where you go for frivolities. When they use vexatious and spurious, they said those cases are vexatious and spurious. It means you've come to disturb their life, to waste their time. They are supposed to be 21. There are supposed to be 21 justices of the Supreme Court. They are less than, I think they are 9 or 10 now. One of them just retired this week. So they have a lot of things to take care of. So you can't be coming with cases that have been decided, almost 2 times, and then even at the level of the Supreme Court. And I was saying it yesterday to Rational Mind. Rational Mind was saying they have to test the court. Yeah, you can test the law, right? And you have to test the court, but you cannot be testing the court at the apex level. you know. So they are saying just that's all. That's what they just actually told them. You can't come to the Supreme Court and trying to be testing.
Enigmatic.
Yes, sir.
What did they say about what do you call Atiku's efforts to file his new evidence?
Yeah, it was very clear now. It was dismissed on the basis of the fact that
It's
first
not
of all,
admissible. It's not admissible. That's what they said.
it couldn't have been admissible because first it lacks the locus, the 180 days, the 21 days had passed already. One Ebabaja should get. So it's already. I think it was almost 150 days or 180 days already before he brought it back. And they reminded him, "What were you doing between June last year to the March of this year when it was published by INEC? What were you doing?"
That's in conformity with what we said yesterday.
Exactly. So what is the voyage of the new evidence, and especially the evidence that has been out there for years? So then they ask him, what even let's assume that we bring. So what is the essence of this why are you bringing this here? What is the essence of it? So they dismissed it, and then I think one of the justices, Inyang or Agbim, eventually tried to like lecture them on how they could have even tried, right, on their deposition, that you cannot make a deposition in the legal chamber of one of your attorneys, that there are certain ways that you can even try it to go to the embassy of that country or so Baba, these people, they at least they respectfully, right, told Atiku, get the F out of our court. But as for Green 120 minutes, you know. So, but let me just go to.
Are you sure they told Atiku that get the F out of here?
In a respectful manner, Baba, because his own was in a respectful manner. They believe that he's an experienced, he's a veteran. He has, I think he's a veteran at the Supreme Court. You know, always losing. He lost against Buhari 2 times. He lost against Yar'Adua. He lost against. I think he's been there for. This is the 5th or the 4th time now at the appeal level. So, you know, when you have 7-0, but when you have 7-0 against you, what is it not F out of our way? And you see the countenance and the way they even. But the most annoying one is that of not annoying. The most exhilarating one is that of our boy, you know, the Agungu Bagre. So the 120 minutes, one sharp. Get
seconds,
out. Seconds everywhere bust.
No, I don't understand what you guys are doing.
Enigmatic. Reno Mokri has responded to just what's happened.
One man.
Yeah. So let's quickly get Reno Mokri's reaction, and then you can pick it up off the back of it. Enigmatic.
Okay.
So here he is.
Oh my God. Obidi fool. Man.
This code Baba enjoy now.
Unfortunately, I couldn't play the sound because of the music, but there it is. That's Reno Mokri's response to.
Mama, is that new video?
Yeah, that's it. You know, he has promised that he's gonna dance. Will be continual dance after so that's the dance right there. So what I expect of Atiku as a statesman, ex-vice president, a veteran in the presidential run, you know, I would say I expect him to gracefully accept his loss, right? And if he actually, I believe he is gonna probably would be coming back in 2027, and I will expect him to start preparations towards that. And then he's quite experienced.
At 82 years, you are expecting him to come and contest.
Baba that is what he's projecting himself to come back, and I will explain that to you in a second, just to wrap everything up. And then he has lost. He knows he lost, and then these people said it. They said these people, they know they lost. I don't know why they are here. By the time we rewind all those things, when we play it back, you hear all these things that I say. They said they know these cases, they no headway to these cases, but yeah, they are here. So what are they here for?
Enigmatic.
They said it. Hold on, let me just conclude. Sorry. So then, as for Obi himself, now, as anticipated, like I said, I will be surprised if he told the righteous and the honorable manner, the honorable path, right, to do the needful. But he is burdened by the weight of his electoral misfortune, and then this may make him choose the perilous path of stoking once again the flames, among his headless mob. Is a political discourse or is a bodily countenance discourse going forward may take a disheartening turn. The way I see it, casting doubts and aspersion upon
I'll be very disappointed if he goes down that path, enigmatic, because call me an optimist, but there's the romantic in me still feels that there's some residues of our statesmanliness within the being that is Obi, and the moment will come that will show that he's a nationalist and a statesman, which we have not seen in the course of his life. But if he's ever going to seize a golden opportunity to show that he has any leadership qualities in him, this is the moment right now.
What like I said, I'm gonna be surprised. I said is funny enough to see that this same man will be casting that as passion, even against the very institution of that judiciary that had, at a prior juncture shielded him from the vagaries of his political fate. And then, but I am very happy that the Supreme Court has resolutely maintained, the faith in our faith that our revered judiciary, shall continue to remain steadfast, impervious to the machinations of people like him, like Obi now, who has the proclivity and the penchant to sow discord, from the shadowy recesses of this machiomanic, mindset, and they're trying to play piety, to the apathy of Nigerian youths. So the pillars of this justice and the integrity of it can never be brought down. And it will continue to buttress our judicial system to understand that you cannot intimidate the judiciary. And speaking like this one man, because I am a product of that institution, right? And then if you are a product of that institution, you shall never be swayed by the cacophony of online provocateurs or individuals like this who do not, who subject themselves, right, to the processes of the judicial inclinations, and then yet, in the same breath, lampooning and instigating their headless mobs against the same judiciary. So I will be very, very surprised if he does that, because I know he will try to, as much as possible, to keep his headless mob. As Trump knew he lost the election, but he had to do the job of keeping those the MAGA Republicans, right, so that he will continue to make them, he will continue to rally them. Whenever he comes back, to campaign for elections, they will always be a fatal idiot for him, that like they are now. So I'm sorry if Prince Daddy is hearing this. I'm not saying Prince Daddy is a fatal idiot, but as it is, you just have to go back to that base, and his base now is the headless mob of the dogmatic, headless idiots, as we see it. So on Atiku, Baba, look, Atiku is not going. He didn't go to Chicago because of this final judgment. His mission to Chicago is basically to project himself as the face of opposition. And I said it earlier that Obi played into Atiku's trap. He played into Atiku's game plan, because Atiku is projecting himself now to be the face of the opposition, going forward, knowing fully well that by virtue of Obi's, let me say, status within the Labour Party movement, within the Labour Party as a whole, there's a possibility, and then by virtue of his antecedents over the years, there's a very big possibility that at a point before the year runs out, he'll be frustrated out of Labour Party, or he'll be like a fish, right, with no water behind the at the back. So at a point, he will have to find this level, right? So now, if in finding his level, Atiku has hijacked, so to say, quote unquote, has hijacked the machinery of PDP. So, and if he has to go to PDP, he will have to find a way to struggle with Atiku first, because Atiku has solidified his base. And then Atiku too is ready for the fight of his political life if he has to remain the face of PDP, because the likes of Wike, Saraki, right, and all of them, now that the case is completely over, now they will have to find a way to say, okay, how are we pushing out Atiku to re-energize and to re-strategize this PDP? Then Obi bringing his head. How is Obi going to fit in with Atiku, with Tambuwa, with Wike, with Saraki, and all of them? And if he has to go to Abga, then Abga now, they've told him, since you promised Abga and you swore an oath that when you leave Abga, you never amount to anything politically again, right? And he has not amounted to anything politically. Oye said it, that this election thing is going to fail. That man said it. So now if he goes back to Abga now, he has Soludo to contend with. He has the likes of Oye and the people that, right, he vexatiously had issues with in the past to contend with. So where does he go from here? That's where Atiku is projecting himself now. So now today's declaration now at the Supreme Court has conclusively put a closure, right, to the electoral cycle of 2023. Now the Atiku part now and Obi part now, Atiku's part is 50% assailable, right? Unlike Obi will have to find a way to reorganize his political life from where it is now. So Atiku is coming back, Babaja. Atiku, even unless PDP denies the fact that, or probably PDP find a way to have the willingness and the strong mindset to say, look, this man, this time around, you can go to NNPP or any other political party, but this PDP, under any guise, we are not giving you our ticket, right? You've caused enough trouble for us. We need to move forward. And then, look, I know Atiku is still in the game. Atiku is not done politically, Babaja. So that's the way I would just say it. And then, I just want to appreciate everyone on the platform. It's been a long, is it 8 months or 7 months? Right? 8 months or 7 months.
Enigmatic, can you please congratulate the president, please? We have to congratulate him.
Yeah, congratulate the president and then stay steady. I want to bring other voices in. I want to bring Emeka in, but I want to also bring reactions from Peter Obi and Tinubu himself to this verdict. But I bring it home, Enigmatic, and then we play 2 clips and then hear from Emeka.
Yeah, all I would say to not even congratulate the president, now President Bola Ahmed Tinubu, for all Nigerians, right? And then to all Nigerians too, right? To even the Nigerians who were not Nigerians 10 months ago, who became Nigerians later, now who are probably going back to not being Nigerians again, right? All of us, congratulations to us. Let's wish Nigeria good, and I pray to God Almighty that may the Bola Ahmed Tinubu's administration favor me and my family. I don't know about you, but for me, it's going to favor me and my family.
It's going to favor me and my
why
family.
Are you so selfish? You're enigmatic. You say for the country now, everybody. Why only you? Okay, Atiku, selfishness.
No, some people they will say it's not their very, to me, that's my own prayer. I don't know about others.
He's not my president. He's not my president.
Everybody, there's something that I observe now. I've gone around the internet everywhere. It's only one man that is operating. Where are other platforms? I want to hear from their side. What happened?
One man, that Ajibola Bashir, the guy that completely destroyed Peter Obi that day. You remember him?
Yes. The one that was wearing the red cap.
He just tweeted something now. Obi's petition was dismissed in less than 120 seconds. Just what I just said here. So now, oh man, this is the highlight of this final judgment.
Good morning. Sorry, I have a work meeting by 8:30. That's in.
Do you want to take this call?
Yeah, let me just so that I can leave and prepare for my meeting. Okay. Good morning. Good morning. Good afternoon. Good evening, wherever you are. I think it should be evening in Australia. Good evening, Thomas.
Good evening, my friend.
Congratulations to the President Asiwaju Bola Ahmed Tinubu. This is the end of the road now. All the speculations, distractions, confusions have been put to bed by the Lordship of the Supreme Court of Nigeria, and we want to thank them for their duty, for raising up to the occasion, and carrying out their civic duty to the country. I'm very pleased with the outcome of the verdict, where it didn't surprise any of us because I believe the Court of Appeal handled it in an excellent manner. So what the Supreme Court judges will just do, and that's why I hear Enigmati saying 2 minutes everywhere done, boss. So they did the job very well done, and all they just needed to do is to stamp the Court of Appeal verdict and move on. Now to P2B and Atiku as well as their supporters, this is the time now to drop any funny ideas that might be going on in your mindset. I think on one platform they were saying, "Oh, it's been bought." No. You are just being unfair to the judges, all the judges who have participated in this election petition, as well as to the country. We keep saying and we keep repeating right here on this platform that you must prove your case, and the case were not proved. Well, we are not proven, rather. So they were busy looking for disqualification criteria, going around in airplanes with their fishing tools, and they brought nothing. And we could hear what the judge, lead judge Okoro, said. You can imagine the waste of time that these people have caused this country. And I hope they will play the opposition party right, and they will not be petty. This is not a personal issue. You've lost the election. It is over now. Rally around together and see how you can contribute positively to the country in terms of either criticizing the policies of the president or making useful contribution that can help the president to move this country forward. If the president fails, I don't know what Nigeria is going to look like. I don't know what Nigeria is going to be. And we will need everybody with the skill sets, the mindset, the ability and capability that is right enough for this country to move us. We are in a bad state, unfortunately. I think we may have to put politics aside and see how we can contribute. I know the president will still extend his hand for fellowship and friendship to you guys so that you can come in and key in into making Nigeria a much better place for just not only ourselves, but for future generations too. At this note, let me congratulate the president again that, as the last man standing, you've been fought left, right, center in all angles, arrows coming everywhere, but you have defeated your enemies. You have even defeated your frenemies, like the Dele Momodu. You have looked them in the eyes and you are saying you are a champion. Truly, you are an Asiwaju of Nigeria, an Asiwaju of Africa. I respect you, sir. You are one to emulate in terms of leadership, in terms of coordination, in terms of ideas, in terms of even implementing your ideas. And I hope you will bring the vision that you have carefully and thoughtfully planned for this country for 2 decades. And hopefully this country will be turned around and spinned around, and the ship will now start moving in the right direction. Congratulations, sir. And at the same time, please don't let me criticize you too. And for the OBs, I'll be watching your space. And I'll be respectful at this moment. But if you continue to disrespect the president, unfortunately, we will not keep quiet. Unfortunately, we will not allow lies to filter anymore. Please note that you are not the only ones that can play propaganda character of a behavior or attitude. You will be met with fire for fire, and if you cross the line, you'll be.
Are you talking to your leader like that?
No, I'm going to definitely. Now is governance. This is the end of the week for him. From next week, we must begin to criticize. We must begin to criticize the policies of the president, and begin to hold him responsible for the things he said he's going to do, for the plans he said he's going to implement. All this noise is now over. Nobody is taking. He's not the legitimate president of Nigeria. Nobody is saying anything. So even if the chatters are still chatting, he can shut the door and either use insecticide to chase them away. But he must focus on the job. He asked for the job, just like he has said, and the job has been given to him, and the job has been ratified by the Supreme Court of Nigeria, the highest court of the land, and his supporters are happy. Even those who are not supporting and hopeful will be looking at him. He's now our leader. Nobody is taking that away from him. So, just as the job demands, he must deliver. He has to deliver. There is no excuse for the president not to deliver. And I know on this show, we'll be here to monitor his progress. And I don't want to say his failures because it will be sad. But his progress, and we would
close mark. We
close marking. He can't afford it. Yes. Close marking. Shadow marking. That he can't escape it. If he does well, we will congratulate him. If he doesn't do well, we will also criticize him so that he can learn from his failures, weaknesses, and improve them to strength and positivity. Thank you very much, guys. I'm very happy today. In the evening, I would, because of my meeting, I don't want to start screaming and start saying, but I'm very elated. I'm happy. The noise will die down soon, and the stupidity will be over. Clearly, I think the ignorance is out of the window. I hope so. And for those who want to continue drinking the Kool-Aid, be my guest.
So you are carrying energy to that meeting, Emeka.
Oh yes, I'm actually facilitating the meeting, so my energy is really high. My energy is really high. It's an exciting moment for me.
Good day to you, Emeka. Good day.
All right, thank you. Good morning. I'll see you guys in the evening. Thank you very much.
The evening is going to be. In fact, I'm not sure if I'll be able to control it. Even it's probably going to be wild.
No, I can't shout. I wanted to shout. You understand? When I wanted to shout, like I like what Enigmati said. 2 minutes everywhere, don't bust. So hey,
engineer is here. Engineer is here. One man. Wow, engineer.
So exactly as Thomas just said, after a long hiatus, engineer rejoins us. So, gentlemen, with your permission, let me skip to engineer, who has a long-standing favorite voice of this platform. He has been away for a while, so he rejoins us at this now moment of decision for the Nigerian state. But engineer, let me build you in with this. So there's been a response from Peter Obi and Tinubu to now this verdict has just come in. So
okay.
let me play you clips of the responses from those two camps, and then you pick it up from there. Engineer, watch this. So I don't think it can be said any better than that lady just said it.
One man, please let me leave you guys. I have to go get ready too. Engineer, you are welcome back.
Yes.
No, Allah. Engineer, you are welcome back. Long time.
Thank you, bro.
All right, engineer.
One man.
Yes.
One man.
Yeah.
Sorry, I wanted to say something to Enigmatic. Has he gone? He left. He
I'm
has
sure
left.
he'll
Yeah,
still be listening, but yeah.
he's listening.
Okay,
But yeah,
okay. Let me quickly say, Enigmatic, thank you very much and you and Ogbeni for being a blessing to this forum. And it's a pleasure listening to you and having met you. But there is one thing I want to point out to you. You need to apologize to Obi, and because we need to understand that it's not Obi's fault. You need to apologize sincerely, one man. And I'm going to say this: we need to apologize to Obi. It's not his fault. The fault is actually from where he's getting the advice from. He said that he got his best advice from a madman. So maybe he's still visiting that madman. He failed to understand that the madman
Yeah,
can
but,
only give good advice once.
when he said he got his advice from a madman, his best advice from a madman, he did not tell us if he was standing in front of a mirror when he got that advice.
Well, man, what give you?
one man, can you please let's make this section. One man, I have an advice. Let's just have quick reaction. Let's make the section in evening be banger. We are letting the cat out of the basket now. I want the evening section to be really, really the banger. Yeah, it's up to you, one man.
All right.
Hello, one man. Good afternoon. Hello,
Yeah,
one man.
let me play. Hold on. Let me play this clip. Engineer has the floor. Let me play this clip. Let's get engineer's reaction because we've not heard from engineer for so long, and then we'll take it from there.
Thank you, sir. I agree. Congratulations, Your Excellency. Congratulations, Your Excellency. Gentlemen, congratulations, Mr. President. Having been confirmed by the Supreme Court as a 5-star general. Yes. As the Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria. Thank you. Congratulations, Your Excellency. Thank you very much. Congratulations. Thank you. Amen. All our renewals shall come to manifestation. Amen. All your job is secured.
Okay, so engineer, the first thing is the impudence of the chief of staff to be having the first speech. I don't quite know. But the one thing also that we know in Nigerian politics is that Tinubu always wins. And that remains the case, engineer.
Yeah, greetings to you all. Good morning. Congratulations to Jagaban. I must say it. And all this while, everything has come to finally the end of the story or the end of the issue. What we need to understand here is Tinubu learned something. He learned something from Abiola. The mistake that happened to Abiola will never happen to Tinubu. So Tinubu is a wise man. He knows what he's doing. He knows how to play what they call politics in Nigeria. Something people don't understand is when it comes to reality, it's not by shouting or by making too much noise. You just have to flow with what you need to flow. Then you see things will go well. If you look at it right from day one, Nigeria, the way we are today, you see everybody will come out and make noise. Then you see the quiet ones, they keep winning and they keep passing through. So at least it's something that we all need to learn from here. We have to join the game and know how to play the game. But if you end up coming out making too much noise or, fighting on social media, all those things, it's not going to help. So one have to learn from here because Tinubu is he's just the man. That's just the truth. If you know how to play politics, then the floor is yours. And I will still say congratulations to him. And hopefully now we'll see changes in Nigeria. Regardless how the money is completely out of order now. So hopefully things will start to, to get into shape. So that's my prayer, and congratulations once again.
All right, brilliant, excellently put. So that's engineer. A lot of people have been asking about engineer. So there is engineer right there. There's nothing wrong with him. It's just work, really. You
He
know.
just work one man.
Engineer, how you do?
And all that.
Oh, Aja.
Nice to, do you know what? I wanted to ask of you from one man yesterday.
Oh my
Wanted
goodness
to ask
me.
of you, which can work carry engineer away like this?
I'm so sorry. I'm not keeping in touch. I must be honest to you. I since I got this job, it's like the workload is too much, and also I book my holiday. I'm going to Turkey. From Turkey, I'm going to Saudi Arabia. Then come back on the 29th of December.
You know go Nigeria. Waiting the
No. Nigeria till next year. I just need to go and check engineering job in Saudi Arabia. I heard that the pay rise is good over there.
Oh, okay. That's good. So yeah, welcome back. So anytime you have chance now, make it a check on us.
Sure. I do apologize for not calling to check on you. I'm so sorry.
All right.
Yeah.
All right.
All right. Let's start sounding opinions and start taking it round. So let's take the first reactions to from Ajanle Koko. So Ajanle Koko, nothing really came out that is surprising, really. It was pretty much to the template of everything that we anticipated. The justices, they sounded somewhat irritated that they have been disturbed.
One man, come on, Ajale Koko has spoken now.
I have spoken one man. You forgot one man.
All right. Let's come
but
to you.
One man, do me a favor.
Yeah.
Do me one favor. Please, can you call your friend Rudolph? I'm trying to join his platform. I don't know what is going on. He is not on. Can you call him?
He is on.
He's on now?
Yes.
Oh, okay. What? Okay. We I couldn't see him. I was wondering that they don't want to show today because I want to laugh. I want to watch what is happening. I want to laugh this morning. So let's go.
They were on, but they are not streaming.
Nobody
they were not streaming.
They are not streaming.
They are not streaming. Yeah.
Yes. No, stay here. This is where all the information is. So everybody stay. Don't worry. I'll phone him later. I usually text him, but I'll phone him later just to say, how far now? That's all I will say.
If you can tell him to join us later, we want to hear his opinion.
I'll send him the link. I'm sure he will.
Yeah, special invitation to Rudolph.
Hello, one man.
I'm actually going to try and see if I can get in Media to join us as well, but I suspect he will go and hide away. But
all of them will hide away, one man. They will hide away.
Yes, okay. It's not even anything, is it really? It's so obvious that this was I don't know quite some people, man. This electoral cycle has really given me personally an introduction into human mind, because when this thing started, I thought these people were joking and they were trolling us, but they actually believed in what they seem to be saying, and that shocked me. How can you say Peter Obi, an unknown from Oka that came 6 months into an election, would defeat Atiku that has been fighting for 30 years and defeat? I mean, what are you talking about? What are you? Can you tell me? And I thought it was a joke, but they meant it. They meant it. That was
one man. Can I interject you, one man?
Oh my God. Let's hear from Obedient. Yeah, coming. Yeah, Emmanuel. Emmanuel.
Yeah, can anybody hear me?
In. And after Emmanuel GD, Emmanuel come in.
Okay, one man. Yeah, making me laugh this afternoon, and I'm not in that good mood to laugh, but it's okay. And first of all, let me give you the platform update for the what is happening. So we're able to inform the police and the local police within that area. So they say we should not make any payments yet, that they are developing their strategy. Though we will only tell them that we are bringing the money, but they are just trying to find a strategy they will use and ambush them. So we already promised them the money anyway. So, but we are not going there to give it to them. And two, the people working with the farm has been arrested. All the people in that farm have been arrested. So we're trying to get information from some of them and see how we'll go about it. So, but the man is, I think, he came back from hospital yesterday. I think the one man called me. I was able to. So we are still praying that nothing will happen to her. So that is for that side. But people that know the story, at least you're able to understand where I'm coming from. So I'm not ready to say it again. So
yes, well done. Keep us updated. But to what happened today?
Yes, to what happened today, I'm not surprised, and we expected that to happen. And for the fact that this has happened this way, so I will say congratulations to President Bola Tinubu. Yeah, so we have no option.
Are you sure you are congratulating President Bola Tinubu or Chief Bola Tinubu? Is he president now? Is he still
one man, we're congratulating him, and for the fact that whether what he was bribe or something, but now he is our president.
Come on now, what are you saying?
So, Thomas, allow me to talk. You don't like somebody interjecting you, please let me talk.
Sorry,
I'm not always in this platform. I have heard when you don't even allow anybody to interject you. So he's now my president, yeah. So what we are looking for now is his policies and things that he'll be putting on ground. But God help him if he failed. So that is that will be the end of everything, not just to him. And I'm not praying he failed, because if he failed, not that he will only affect him alone or his people, it will affect everybody. So I will be praying for him to succeed, because Nigeria is sinking. So we want someone that can get it right. So that's the only thing. I'm wishing him well, and I wish him all the best. So on our own part, I'm sure that even my principal will also say something and say, let's move on. We all know Peter Obi is not a troublemaker. You will see when he will put his tweet or his conference, you'll see. In fact, this tomorrow on there, he's coming to give an account of his campaign, all the money and everything, what they want to use the money for. They have about something billion remaining. So they actually had a plan for the youth. So when they will come and lay those plans, what they're going to do with it, and how to carry the diasporas along. So they also had a lot of plan, not just because of elections. So if they lose, this is what they're going to do. If they win, this is what they're going to do. So Peter Obi has come to stay. So let's watch him closely, what he's going to do. So, but I wish him, our president, the best. Let him just do well, because the youths are keenly interested from now on. We all know that. So I wish him the best, and I'll be praying for him to succeed. And let him know people, he might have good intention, but what of people around him, that you can see a lot of people are coming out and say that he is not the one giving orders in the Astro. I wish that will not continue. He should be the president, and he should make his decision from, not that he say he's not the one that did it. Let everything that coming from president be ordered by him. We don't want to hear excuses like Buhari. We want a leader that will take responsibility and be responsive. I wish him all the best. Thank you, one man.
All right. Thank you, Emmanuel. So thank you, Emmanuel. So Jide, you're up next. So a long and hard fought race. Lots said, lots in between, a lot of drama, a lot of laughter, tears before bedtime. But as they say in Nigeria, after the verdict from the Supreme Court, then the matter is now left in the hands of God. So there it is. Tinubu, your president for the next 3 and a bit years. Jide.
One man, thank you very much. Good afternoon to everybody on the platform from Nigeria. Tinubu has been the president for me from the day he was announced, and he's still the president. And I just want to, it's just funny because I I was just listening to everything the judges were saying, and it was like Ogbeni and Enigmatic wrote the verdict, and those people were just reading it. And in fact, I was so happy because when people say it is bribery, this is something that has been discussed on our platform, and people that are experts in this field has analyzed. They've told us this is why it's going to be like this, and why it's going to be like this, and why it's going to be like this. And the judges came out and repeated the same thing. And some people are still saying maybe something. No, it's not. For me, it's not new, and it's not surprising, because even their principal, gets advice from somebody that is not sane. And like I said the other time, if you go and it's not a bad thing seeking advice from a madman, but the advice can come once in a blue moon. Something sensible can just come once in a blue moon. But I think where Obi missed it is now taking the madman as his special advisor and going there all the time to seek advice. And the man kept on giving him very, very bad advices. And that's why all these shenanigans, all these conference, even the judges went ahead and said, you are calling conference, worldwide conference on issues that is in the court. It shows that even their lawyers are rookies, or let me say they are inexperienced. The guy should fire them and get his money back. Because these are the people that should advise you that, come on, this case is in the court of law. We don't need to say anything about it. Let's keep our findings to our own self. Let's keep our cards close to our chest, so that we don't even give the opposition let our cards out of the bag. And but they know they don't have a case. So what they were trying to do is to rally around the masses, instigate people, try to create another NSAS and things like that. But Nigerians are wiser now. Nobody is going to go and die because of you. Nobody is going to die because of one Gregory, Peter, Obi. Nobody is willing to die. We have our lives to live, and we will not die because of your own cause. That's just it. So for me, it is victory for democracy. And I believe anywhere in the world where they listen to this court proceedings and they saw what the judges were spilling out, they would know that there is justice in Nigeria. That these people told them point blank, you came with an open-ended accusation that he is not qualified to be president, but you never stated why. You now went after the appeal court to start seeking for certificate everywhere. This is just pure nonsense. In fact, Babajide Kuku said yesterday that they should be fined. I don't know. Are we serious about the forex we are looking for? We are not serious. The justice should have given them each $2 billion fine. Tell them to pay it in dollars so that we can get. If I'm the one, that's what I would do. We say we are looking for money. These guys have the money now. Why will you be disturbing the peace of Nigeria, disturbing everybody? You've turned the whole process to a child's play, a baby.
Do you have idea of how much they pay all those sons to defend them at the tribunal and this thing? Do you have idea of how much they will have paid?
I don't know, Babajide Kuku. I don't know, but I know they pay them.
If you can find out, maybe from Ogbeni, we should be able to have idea of how much these people must have paid for this their fight in the tribunal and the what do you call it, and Supreme Court. We should be able to have idea of how much these people will have paid, so that we can really know how reckless they are as people. You understand what I'm saying? So maybe if Ogbeni no, because Ogbeni have defended an election matter before, so I think he will have idea of how much with all those sounds representing those people. Because sounds they don't charge people, they charge so high. So we should be able to have an idea. I think that I have interest in that. So maybe later when Ogbeni comes, one man and everybody. So. If I don't remember, so someone should please want to know. Thank you.
I will remind you. I will remind you, because you see, the truth of the matter is this. Like I said, these people in fact, they should have been fined in a way that leaving that place, they will be thinking of all the assets that they will sell to pay. They've just wasted our time, wasted our precious time on frivolous accusations and things that are not sensible. It's like having an elderly person dancing naked in the market square. That's what they came to do. They're just dancing. They are just dancing around and just shouting, calling names, instigating youths. Do you know that what has happened during these 100 days after?
I wanted to go to Ekenele next, but oh no, he's still there. Okay, so sorry, I thought we lost him. Carry on. Yeah.
Okay.
Excuse me, Wama. Are you beating around me? You don't want to call me or what? I don't understand.
Danduma, we're saving you for last minute now. You know you always save the best.
No. You know my internet's always having problems.
All right.
So
I'll come to you after Jide then, and then
okay.
can all right. Jide, back
perfect. To you. Thank you.
Okay. So what I was trying to say, like,
I have to go out.
All right, Jide, carry on.
Okay, so what I was saying is that these people have just wasted our time. Things that we should be doing are not what we are doing because of, and these people, their aim is just to instigate the youth. One man, the past 100, after this election, we have been fighting serious information war in Nigeria. And that's why I don't see these people, even if they come back and say now they are after the court case, they're willing to work with the government. The government should distance itself from them. Even the president should, because these people will become cancers that will destroy the government again. You know, I feel the best thing, the most ideal, honorable thing they should have done is, okay, come back, try to start guiding the president in there. Okay, we do this, come to the TV, let us know. I gave them this idea. I'm submitting this what's it called, initiative to the government to employ, so that this, and people will start seeing like you have brain. Yes, this guy too can do it. Then in the next election you come and people will vote for you. But these people are just sour, bitter losers. They are wicked. And they have very, very bad. In fact, if I was the judge, I would even try them for treason.
All right.
And I like the fact that they did not even do well at all on Obi's case, because that statement that he made yesterday, he has lost everything. Calling them cultists, it's out of it. One man, thank you very much. By in the night we will laugh very well, because I want to laugh. I want to make gestures.
Don't worry. Just bring your popcorn in the evening. That's just it. So Danjuma, you're up next. So Danjuma, so there it is. The election finally comes to a close. Whether people agree or disagree, whatever their sentiments or political leanings are, the 2023 session has officially now closed, and all the electoral materials are packed into storage, both at the party and at the governance level, to be brought out again in 2027. So, President Bola Ahmed Tinubu, Commander-in-Chief of the Nigerian Armed Forces, your president for the next 4 years. Danjuma.
Yeah, thank you, Warman. And I greet everyone from the family, from the platform. And Ajali Kuku, I missed you. Engineer, I missed everyone. These are all people from this place. I see no reason why, Warman, you could have They could have give those guys ovation every before they start the program all the time, because those people are they are always with you. I love that. And moreover, the reason I don't normally come is on little personal problem, here and there, and due to work, the system of work this time around, Jamie, really they are short of workers, and when you are working in the big factory like Amazon, they always try to make use of you, and moreover, you don't have time for yourself. But everything is going well.
But you they make money,
too
man.
much
Now
money.
money you they make so now. As you don't have time for all. Money they enter your pocket, you don't have time.
No, Ajali Kuku, say man no go die now. We come on for art for purpose, so we need to find this money by all means. You understand?
How you day now?
I know. I missed you. Seriously. I miss all of you now. But I still listen to now. Just that I know they like to come online. You understand?
Okay, that's good.
Yeah. And let me go back right from time. I'm Omoyele Oshowore, best candidate. Fans are me. But the problem now is that when they say we should choose among the evil, which one is the more better? I prefer Tinubu. Every time I always stand on my waist. You understand? But for me, my preferred candidate is Omoyele Oshowore. I don't fucking care what people say about him. But that is my candidate, because even Dick Badgewell, when they are talking about Peter Obi, from the beginning,
you know about Badgewell too.
For South Africa now, why no go no? No go no. When they talk, when showing calf talk, I believe I was talking exactly. I said, look at it. This man just because the new, should I call it the new fantasy people in Nigeria that always believe that let's assume that we need to change the paradigm shift. Look, these people, maybe they are first time voting from Nigeria. Those people is Omoyele Oshowore and work. But at the end of it, this man come from nowhere. He thief all those people around Omoyele Oshowore and he use them against him. But that is not the problem. But when you see, when people are, we just need to forget about tribal sentiment.
Danjuma, are you there? Am I off? Can anyone hear me?
Yeah, I can't hear him either.
But I was I don't know why people are just so, blind. They don't see what I'm seeing as I'm not speaking for myself right now. I'm speaking for my people. A donut, especially from Oshomole, where a donut, Auchim, where Oshomole come from. Even the 25% that Tinubu have in Edo State is a donut that deliver into Tinubu, because Oshomole told them that this person is the right person. Maybe Peter Obi he have his way from Benin and Insha, but a donut, nothing, nobody vote for him, nobody know him. You understand? That's why when you mention those kind of things, they will laugh, look at you, they will laugh at you. You understand? From the donut. But now, since Tinubu is already win, and now the Appeal Court, Supreme Court have already said that Tinubu is the winner of the election. So this propaganda and the rest, the person no go school, this thing, because I'm ashamed sometimes when we see alone people, the way they I can't say that one ethnic group will just promote bad image towards Nigeria, which is very bad. This is what we need to try and avoid now. I will sit with some African country that is not up to my state. They will be speaking rubbish because you know why? Because our blogger just believe they are looking for money. They will not even hide even little secret we have. They say it's a drug dealer, it's a false certificate. These are the only problem that sometimes is annoying me. I'm not talking about now who won, but let's try and cover our shame to ourselves. No, because every African country have this problem. But you can't see them on social media. Look at Ghana. Ghana is collapsed totally. But have you ever heard that Ghana blogger come to online say rubbish about this their government? No. Why is it that it's only we Nigeria always having the thing is annoying? I'm sorry, but let's deviate for this issue right now a little bit. Let's talk to ourselves. What are we want as in Nigeria? Even a little country like Sierra Leone that is not up to 8 million, when they are talking to me because of what our social media always show them, the picture they paint to them. In fact, I don't even know how to explain myself to them that this is not real, because they believe everything. It's we in Nigeria that maybe sometimes when they put something on YouTube, we say, okay, this one is propaganda, it's lie, this one is not fact. But all those people, they believe everything you give to them. They believe it. You like it or not, if you will try to defend, they will say, no, not truth. You know, we just need to avoid those things. We just need to try as much as possible to promote ourselves. We should forget about, I understand that tribe, I understand that it play a lot from our politics, but we should learn how to at least respect each other. We can't build a nation in this way. Now, everybody is telling Tinubu to do well. But we, the Nigeria, if we can't support him, that man will not do nothing. 4 years we reach, nothing will change. I'm telling you the truth. Not that I'm supporting, I'm part of Tinubu, but the way we are doing things, no even government that will do well. Don't be surprised. People will come out on this platform tomorrow. We say because of him or she and his wife having problem. He will say because of Tinubu, this dollar that is increases because of Tinubu that make his wife run away from the house. We just need to try as much as possible to try to promote good things about ourselves. We should not always try to promote hate speech, this religion problem, for ethnic problem, which is very annoying. You understand? When we have platform, we need to use it to propagate good things about our country, not the other way around.
All right, thank you, Danjuma. So thank you, Danjuma. So Ekene, you're up next. So Ekene, the Supreme Court has come in, but even so Ekene, the Supreme Court has come in. So even though that ends the legal opportunities in Nigeria, there is still a window for the obedience space. So are you going to take this now to the World Court in Hague? Ekene, let's hear from you.
One man. Thank you very much. Anyway, if you are very conversant with me, you should know that I've never laid my emphasis on this court issue right from the beginning. So if you have followed my thought very well, because I already know the outcome, I already know how it will be. So somebody like me, I was able just to follow it because I'm at home, because there is they close the lab. If not, I wouldn't have time to listen to all those things I read in there. I don't have time for all those things. I know the response. I know how it will go. Even though my argument on the 25% is still the value that court gave. I said it here on the platform that I don't believe that 25% is enough to disqualify a president that won more than 25 states. So, but that is not the case. My only problem is our law. Our law is not encouraging, and that is the only thing I'm looking at whenever I'm hearing all these judgments, because all these judgments seems that there is no way that a common man can fight. Even anything you want to defend, whether you want to, no matter how you want to defend it, you must see it in that judgment. There is no way a common man can fight. How can you question INEC? No way. Even if you go to the polling unit to vote and they kill somebody, you don't have anything to come to the court to present. There is nothing to defend. You cannot defend yourself in our society.
You can question. We have cases, hold on, Ekene. We have cases where people challenge the results of INEC and they won. And
not in the case of presidential. Not in the case when it comes to presidential, there are peculiarity about it. You see, it is not something that Ajali Gogo is not something that started today. It's very
No,
difficult.
they
I
can't
said it
prove.
right
They
from the day
prove,
this election happened, though. They want to go to
can't
court.
prove
I
their
said
case.
it here. It's very difficult to unseat a sitting
They
president.
challenge INEC. They took them to court, but they failed
Who
to
are you going
prove
to
their
challenge? Okay,
case. That
even in this current administration, Tinubu has already appointed REC officials in almost all the states. What are you telling me? Which means he's ready for the next 4 years and in the next 8 years. The society is very damn and the law or lawlessness and all that. So for me, I never expect anything good. I never expect any positive outcome, and it helped me to live healthy. So I cannot put my trust on something that I know I cannot fight. The only thing I know is that we will stay calm, continue to criticize in a normal way, and build a good political party that can maybe put more fight. If we can put more fight, the last fight was okay to me. It was very okay to me. So I would want us to do more. I said it here. Put more fight and not be discouraged, because even the judge said it, that if the facts need to be told, that even that law, even that electoral act is capable of bringing people's as in killing people's emotion towards the INEC or going out to vote. It will bring all about voter party. Nobody can question that. It's already happening. In the next election, people are not feeling comfortable to go out to vote. In this election that is coming in November and all that, people are no longer to go and they begin to change wars with INEC. So that's the negative effect of it. But somebody like me, I would not be damn negative affected by all this nonsense. I will just do the right thing that I have to do as a good citizen of this country. Go out there to vote, campaign for the person I have to campaign. I'll continue to do that. Maybe definitely one day, God will get it right. But for me, there is no way a common man can challenge this system that I see. No matter how you want to paint it, no common man can challenge it. No, even if this Showole, with this system, how do you expect Showole to become president, Ajali Koko? How do you expect him?
it's because you
Even if you
people
want
did
him
not
to,
support Sowore
even
now.
if you
It's
want him to
because
be, even if he's your
people like
candidate and you
you.
want him to be,
No, it's
if you want
because
him to be
people
the
like
president.
Hold on, Ekene. There's breaking news. There's breaking news coming in. Let's go very quickly to the news that is breaking, Ekene, and you are the best person to react to this. So breaking news, Ekene.
One man.
So that changes everything, doesn't it? That changes everything. Ekene,
That's. I know that is what you people want to put out tonight, but it's not anything to me, because it's only the people that only put their hope on this tribunal that you can be playing all this video for. For me, it's nothing to me. It's nothing to me at all. So my only challenge is, will Bola Tinubu really affect our electoral law, which I don't see it coming, because the judgment means that even the electoral transmission of results is not coming to Nigeria very soon. Maybe at least for the next 8 years. There is nothing like electronic voting in our country, which is very good for which will add more value to our election. But will the president be courageous enough to change that system, to affirm it and make it more progressive? I don't see it coming. That we are still going back as a nation now. We are still going back. So, and that is the challenge. So if he will be, the other day we are talking about diaspora voting. A lot of APC is condemning it, which means we still want to depend on that analog system. Where you go to the polling unit, you kill, you fight, you use all sort of weapons to snatch anything you want to snatch and present it to INEC. Then you tell the other one to go to court. Then you go to court and do whatever. So for me, the system is damn very bad. I don't see the common man getting it right in this country. Just fight your way in. I am happy they legalize everything so that in the next election, if P2B should come out or any other serious candidate should come out, they should know it's not all about mouth politics. They need to go into word by word, plan their machineries, and fight. It's all about fight. Election is all about fight in Nigeria. If you fight, you win. Just like Tinubu put it.
Hold on. What did you just say? Did you say election is about grab it, snatch it,
yes,
and run away with it? Eh?
Yes. Grab it, run away. Tinubu said it now. Many people say talk the man is not serious. He did it.
Not that I want to disturb your monologue, but did you listen to what the judge said? Because he said election is about voting. So if you think Obi was cheated, why did Obi not prove arithmetic, basically vote count? That's exactly what the judge said, and that's what we've been saying on this platform. If you're going to wait, I can parabole. If you're going to if you want to change election results, don't be coming up with technicalities. Come up with vote count. Obi fell short. It did not show in any place where my vote is greater than Tinubu's vote here. It did not show it, and that's what the judges said. That's all I have to say.
Okay, the only thing maybe he didn't show, but I don't know what those boxes was doing in that courtroom those days. They were bringing those things. I don't know the reason for all those things. All the witnesses he presented, all of them were not regarded.
So they don't
Nothing was. How do you want him to explain again?
Those
boxes are baguette, man.
So what do you want him to explain again, Kulata? All those things are the issue. All those things are the issue.
Did you hear what I just said? Those boxes, you know what they did in those boxes?
They are baguette boxes.
They went to IRev and started downloading all the things that they said is blood, and they printed it. That is not vote count. Did you hear what the judges said about IRev? A point that I've been making ever since. That IRev is not a collation. It's not a collation device. It's not a collation portal. So anyway, there's no point.
The only thing is that the only thing I have to say is this, Kulata. For me, I already know, because left for me, if I have this money to play this politics, I know it's the same. Let us be, as in, I see it now. I see it happen. Bribe your way, buy the police, buy the army, do whatever you want to do. Then you have to tell them to go to court. They know that you cannot get the evidence. How can you get the evidence? 1,700 polling units. Where are you going to get it? It's very difficult now. With the short, they tell you this one is 21 days. This one is 180 days. This one is. How are you going to present it? The law is meant. This our law is meant for the rich, for those political class. It's not meant for the common man. So the only thing that will change it is when God, maybe His infinite mercy, give us somebody that will have the masses at heart, at least to begin to change most of those negative laws against the common man. That is when we will begin to get it right. The president has already been there now. For his policies, has been already rolling them out. So I'm not saying that he's not. He's already the president. People saying that he's now the president. I've already seen what he can do and what he's doing. So there is no new thing about it. It's going on governing. So there is nothing surprise about it. The only thing is that at the end of his 4 years, we'll just come back here and they recount and they give a record of what he has done. Then we know who will now choose to be our next president. Because for me, if he performs very well, I know the areas that if he performs, Obi will not have the mind to come out to campaign. But I know the areas, if he didn't perform, Obi then will still be more bold to campaign the more. And those areas I'm looking at it. He's never started anything there. So maybe in the next 4 years, we'll come back here and analyze it. If that area he has done well, then he can continue. Nothing is there. The only thing is who will move the country forward. But I'm not seeing it for now. Thank you, one man.
All right, brilliant. Ekene, we're going to have an epic blowout in the evening. So this is just this is the starter to the main course. But We'll go on to Kulata to hear his words, but before we go on to Kulata, let's just take this 1 minute, whatever it is that Reno Mokri has
From
to
the
offer.
day I was born till today, I have not suffered the way I've suffered from the hands of obedience. And I'm telling you, Peter Obi, you will never be president of Nigeria.
And you will continue to suffer. So, this one never suffer self. See this one.
One man, play it again. Did he just? Is that a new video from him?
I'm not sure how new it is because I
He
thought
did
it
it
was.
this morning. He did it like an hour or so ago.
Is this post,
play it again. Play it again.
is,
One man,
is this,
please.
Is this after the verdict or before the verdict?
After the verdict, immediately after the verdict.
All right. Okay.
Baba, you
From the day I was born,
woman.
not suffered
Sorry,
the
let's
way
hear
I've
from him.
suffered from the hands of obedience. And I'm telling you, Peter Obi, you will never be president of Nigeria.
All right, I'm just mindful of the music. Let's see. Does this speak? All right. So there it is. So LUP 22. Kulata LUP 22.
I was going to tell you that music is so old school.
Ṣé Atiku lọkùnrin ṣiṣẹ́ fún Ṣáàgbó àbí Tinubu ló ṣiṣẹ́ fún?
This guy is working for his own wallet now. He's just milking social media coins, and yeah.
He's an experienced politician. He knows how to play the game. He's just playing the game in the best way that they can benefit him too. Do you think he's stupid now?
Reno knows what he's doing. He knows what he's doing, and he knows how to he plays the obedient the way a puppet string. When you're pulling a puppet, that's how he yanks them. So and again, this song that he's playing, Woman, don't worry about it. It's so old school. I'm sure the person that sang it is dead. It's one of those 80s pop music. Anyway, the judgment, I mean, it was so short. I was in between sleep, so I switched to channels. Then I had audio issues, and I switched to Arise. But I was just hearing a few snippets. I thought it was. I mean, I was expecting something 45 minutes or something hours like the last time. But I think these guys.
Sorry, Kulata. There was only really one decision to be made. If they were going to admit that Chicago State or not. If they were not going to admit that Chicago State, then they didn't really need more than 5 minutes because all the work had already been done.
Yeah, but assuming you had a dissenting opinion, right? It was 7-0. Now there was not a single dissent in any of the opinions. But look, from the very, very beginning of these things, I looked at it and said, look, if there was anything at all, maybe Shetima issue. But once Ogbeni broke that Shetima thing down, it was clear to me because anybody that read that electoral law knew that this was just a farce. How are you going to say I won an election without showing the vote count? How are you going to elevate IRev to what is not designed to be? IRev is just a viewing portal, nothing more, nothing less. Collation is manual. We've said it many, many times. So if you actually understand the electoral laws, you'll have known that these people are wasting their time. And I just like how the judges, they cut the fat, they cut the bullshit, and they went straight to the point. Bang, 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 bang. You can't, you did not show with vote count that you won the election. You did not bring PU people to come and show their copies of their vote count. You are going to bring I can't even remember the word they used. So it's a captain obvious, but some people will learn the lesson that maybe it's not a good idea to maintain your echo chamber. Maybe you should be letting dissenting opinions come to your platform so they can give alternate views, which may be based on the facts and not just your feelings of what you wish to happen. 25% in Abuja.
Are you referring to Rudolph? Are you referring to
Rudolph?
No, mention it now. This is the time for us to tell the truth to ourselves. It's not.
But it's not just Rudolph, though. It's all of those places. Elvis, of all of them, they
All
just
those,
rage one
yes.
narrative and attack anything else that wants to
Yeah.
counterbalance. Yeah.
Yeah, so I mean, now for people, I mean, Rudolph Own, he wants dissenting voice, but the only thing is folks, they attack those people that nobody's encouraged to go there. There are other places like the Niger Watch and the Watch One that actively fight against any dissenting voices because their breeding is a breeding ground for like them David Koresh kind of like a cult. It's like cult membership that you cannot disagree with the cult. But at the end of the day, you just end up making noise. I don't know where grown adults think that by shouting, screaming, yelling, somehow is making their vote count increase, or somehow they're intimidating the judges, or somehow. I mean, everybody here, they're 40, 50, 60-year-olds talking, and you think that life experience has kind of like shown you of how rational of how rational things should be done. Like their processes, their laws, their guardrails, all these things. You coming to shout and scream and just being all emotional is not going to get you anywhere. And that's exactly what we got. Anybody that's been following our conversations here will not be shocked about this. I mean, honestly, this one is just to come and rub it in and do yeah. I mean, was anybody that visited this show that is intellectually honest with themselves, are they going to say that they're shocked with what came out? No, you can't say you're shocked. Even the obedience that visit here know enough, if they're open-minded, know that of course this was always going to be the verdict.
It's almost to the letter what the anticipation was. The only thing that is not clear yet is if cost was awarded, because there was the expectation as well that the justices will punish these people. But if that cost punishment, was it applied? I'm not clear on that yet.
I did not hear. I did not hear anything about cost though, because cost is for like a frivolous lawsuit. So I didn't hear anything about the penalty or cost. Because if the judges awarded that, that will be taking it a bit too far. But at least now, those lawyers now can pay for their new G-Wagon. All those cars you see in Lekki, not everybody is doing 419, woman, everybody. Some people are making a honest living. Those lawyers representing Atiku Obi, that's honest work. Like, maybe they're dishonest to their clients, or their clients. Look, you can't tell me Obi that won with the court by actually counting votes. It's the same Obi that will believe he can win in court by not counting votes. So Obi probably knows. It's just more like what's behind the charade? What encouraged them to continue? Is it because they have free money that they can use to pay all these lawyers? Because of course they're using all their donations. Because you have to think about what's Obi's motivation? Trying to come from 2.9 million votes. I mean, that's ridiculous. Atiku trying to come from like 2 million votes. That's also ridiculous. So what's the motivation behind it? Because at the end of the day, they knew we had an expiry date, which is 8 months after the election. Then how does this help them towards 2027? So at this point in time, if we want to be looking at politics, I want to focus on governance. But anybody that wants to look at politics, yeah, we'll be looking at, okay, so who is in the pole position? Because at the end of this charade, because they knew it was a charade, so one of them is supposed to position himself as the guy in the pole position of opposition, the Aritin Senna in the pole position, the person leading the pack. So we need to answer that question now. Who is the lead opposition now? Because with this exercise, it's not clear to me.
Senake, that's really old school, you know. You've had Schumacher, you've had Montoya, you've had Lewis Hamilton in between that.
Senna is not my hero.
Senna, no.
Senna is my hero any day. Maybe because he died. But it's still...
Can I ask you a question, please? Please,
sure.
Can you please shed more light on why why, because I knew on I think it was 2 sections ago, you had an argument with someone that was talking about where they got the court injunction on the certificate thing from. That it was from the office of a lawyer. It was not this. But you know that when the justice was addressing it, they said that the document does not even carry a seal of a court, does not carry a
Yeah.
signature. Why is it, please? I want to ask, why was it not treated as a frivolous submission, and why did they not fine them for it?
I mean, fine if they had fined. I mean, you can't fine them for an attempt because all they had to do was apply to say that, okay, can you open this case, and then they say no. So you can't fine them for saying, okay, can you open this case? So you can't. That would be excessive. You get what I'm saying? Because you're allowed to ask, and they're allowed to refuse. So they refused, and that ends it. But I mean, all those things, the way people were describing it, it was as if that deposition was held in a court of law. They hold deposition in law offices everywhere. And I mean, they'll let you know that, hey, you can't lie, you're under oath and all that stuff. So, but because Nigerians don't understand anything about America, same thing, they don't understand our, the way we handle degree certificates. So, everything, they just, when you are hanging on to a string, the supporters are the stupid ones. The candidates know they knew what they were doing all along. Because my conclusion about this whole exercise is both of them are positioning themselves for 2027. Who is going to be the top dog in 2027? And
Do
I
you
think between
think,
Atiku and Obi,
sorry, do you think Atiku has handed over the baton of a serial loser to our man from Orca? Is that what's happened today? The baton of serial loser?
no, Atiku still wants to lose one more time. Because he's still, that's what I'm saying is, at the end of this exercise, there's no clear winner between Atiku and Obi. As in, who's going to be the pope? I think Obi is actually in the worst position.
Hold on, Kulata. Atiku will not forgive Obi for what Obi did to him. Obi is the one that scuttled the chances of Atiku in this last election. So
Yeah,
Atiku out for him in the 27, to destroy his own. Too. So let's wait. Politicians, they are very treacherous and they don't forgive each other. So we'll see.
We'll see. But Atiku, I mean, the thing is, what Atiku needs to do is he needs to get Obi out of Labour Party. So Obi becomes, because if you guys notice, 2 weeks ago there were 2 boys that came to Rudolph's platform. One of them is called Alaru of Nigeria or whatever. They've created something called Compact Deck or Com something something. They kind of like, when they don't associate Obi with that platform. It's a website which is supposed to take quote unquote obedience, even though they did not explicitly call obedience. If you go to that website, you'll see Peter Obi all over that website. That is what I suspect is the vehicle that Obi wants to use, just in case they kick him out of Labour Party or he has to leave Labour Party. He will use that vehicle and try and transform that into a political. He wants to use that as a political movement, but he's going to ultimately maybe use that and transform it into a political party. And that kind of like now frees him off Labour Party. But at the end of the day, he's weaker. Atiku will be stronger. But he's still going to play the spoiler to Atiku's chances, depending on, of course, everything depends on how Tinubu performs. So, I think I'm even rethinking. I think Atiku is coming out stronger from all this, and that's why Atiku will run again in 2027, because he does have a chance to defeat Tinubu if Tinubu does not perform. He also has a legitimate chance because by that time, northern grievances will be much, much higher. Because if you notice that there's been a lot of grumbling from different quarters up north, I will not be shocked if we have some sort of like coup in the Senate. Well, not a coup, but an attempt of takeover to wrestle more power to the north. Whether Akpabio is going to become a victim or not, but I'm noticing a lot of grumbling up north to just to position themselves well for next elections. Because by next elections, if Tinubu wins next elections, Tinubu will do whatever he wants at that point. He can restore, he can do whatever the F he wants if he wins the next election. And doing whatever he wants goes back to all his held ideas of AD, of Awolowo, all those things, which means more regional government, more this, more that. And of course, those guys they will want nothing to do with it. So I see Atiku particularly strong in 2027 if he goes back for it. And see Obi weak. Because before I was even thinking who won between Obi and Atiku. Because I'm not thinking this is not the competition with Tinubu at all. Tinubu has won the election since
But
February.
age is not friendly to Atiku. It's aging fast. I mean, it's going to be 82 years old in 2027. Will it be healthy enough to even carry out any campaign? I mean, I don't know how we'll be able to do it. He'll be old, he'll be older, and his physical condition might not be good too well, to come out and say you want to because now if you watch Atiku, that guy he it's like he drag his leg as he walk, he's though when he speak like somebody in his 40s, but the body
has taken a beating.
That's it.
But the thing is, if you can prevent cardiovascular issues, because if you can prevent him from having a heart attack, heart attack or any sort of like cardiac event, stroke, if you can prevent that, even though it may be slow, sluggish, you can manage some of that with stem cells therapy. I mean, the medicine nowadays, if you can afford it, can prolong your life. As long as, the main thing is atherosclerosis.
Look at that. So we're talking about yet another sick note president. Sick note, yes, again.
But that's
when are we ever going to have a healthy man as the president of Nigeria?
Unfortunately, after 2027, because look, it's 2027 is between Tinubu and Atiku. Well, that's if you look at it now. We don't know what Wiki and Co will be able to help Tinubu, but I see Obi now after the way I was talking through it, my thoughts were becoming clearer. I think Obi is beat down, in my opinion. I think the North may not come out as well for Tinubu because also he still has some time to adjust his appointments. Like, come on, if he's appointed all the strategic part, then every other thing you can as well just give it to the North. As long as you can find trusted people in the North too. Like, he needs to dial down a bit. I know he has to perform. I know all that stuff, but there's also politics. So Tinubu may be in a precarious situation for 2027, and I think we may be able to take advantage of it.
Kolata.
Yeah.
Kolata. I think Tinubu has done very good for the North in terms of appointments. He has given them a lot of appointments. But it's just like the direction that the people that are getting the more juicy part of it are not the usual people that normally get it. Okay?
Yeah, but you're speaking from your own opinion. Look at it this way. Let me make this salient point. These are people that don't have to contend with what they're contending with. Meaning the so-called juicy positions is kind of like taken as their birthright. So they're contending for second fiddle right now. If you're used to being the preferred, the baby of the house, do you think by giving you the second fiddle position, that will satisfy you? Because that's not what you're used to. Let's say the honest truth.
I understand
They,
collateral.
these vaccine positions, they're used to getting them.
No, what I'm trying to say is this. Tinubu is trying to tilt towards, the north is just divided into two sections, northeast and the
Yeah,
northwest.
the Canary side and the Fulani outside
So
side. I know about that.
I think this Shetima influence is also a large is a big factor to whatever is happening in this government. Okay, and the people that normally own this thing before as their birthright are now seeing it like they are being sidelined, even though they are getting appointment, but it's not the juicy part that will have come to them. Anything that goes to the north that as juicy goes to the other end, the other divide of the north. And that's that I think that's where the complaints is really coming from. But
Yeah, but the numbers are not there. It's also a math. The numbers are not in the
Let
northeast.
me just add this as well, Kulata, and then you pick it up. That 2027, the Tinubu's fear should not really be Atiku Abubakar, who is a serial loser anyway. I think his fear should really be Kashim Shettima. And I'm saying that off the back of something that Ribadu said some time ago when he was on the platform. So he was saying then, there's this real mortal battle between the Fulanis and the Kanuris. And the Kanuris have been after getting back at the Fulanis for a very long time. And what Ribadu was trying to get across to us is that the Fulanis, they will even prefer Nnamdi Kanu to be the president of Nigeria than a Kanuri man. So now, if Tinubu gets his second term, then the possibility of him handing over to Kashim Shettima becomes more of a reality. And that is something that the Fulanis will, to the death, fight. And what they were hoping was that El Rufai will be in there to counterbalance that and present that possibility of that takeover from Tinubu. So with El Rufai not in situation, Kashim Shettima are flying high. And if Tinubu gets a second term and hands over to a Kanuri man, that is the end of the Fulanis as a power block within Nigeria. So I think that might come into play in 2027 as well.
You're spot on. Hold on, Judy. You're spot on. And that also brings the incentive to correct the F-up in 2027 because PDP will put a Fulani guy on the ticket to not risk a Kanuri person becoming president in 2031 because Shetima is a young guy, he's in his mid-50s. So that's what I'm saying is 2027, it may be, as of today, is Atiku. As of 3 years' time, it may be Kwakwanso, it may be someone else. But 2027 is going to be Tinubu's political battle of his life. Whatever happened this time is trivial. And this time, honestly, it was a walkover because Peter Obi was there to play spoiler. I don't know if Peter Obi is going to be there to play spoiler in 2027. And the Northwest is going to come out gun blazing to try and get power back in 2027.
Could we also extend that to say that the 2027 is a battle really between, it's a battle for Nigeria to permanently wrestle itself from that Fulani hegemony? Because if Tinubu wins through in 2027 and we have 8 straight years and it doesn't hand over to a Fulani, and then we get another 8 straight years of a Kanuri man, and then it comes back to the West, that is the end of this Fulani overloading that Nigeria has experienced.
Monica also is not going to go to Southeast after 16 years.
No. Since in 2031, where do you think it's going?
South.
Yeah, it's not going to the Southeast now, especially after what Peter Obi just did now. When everybody saw just the nakedness of the clannishness, I can't see it ever going to the Southeast.
No, I don't think in my lifetime it will go to the Southeast.
Kolata, can I just say something to what one man said? One man,
Yeah.
from my own calculations, you know when El Rufai was not picked, I came on this platform and I said it has a Shettima handwriting on it, and the calculation is already towards 2030, whatever. It depends on Tinubu's health if he's going to go for another 8 years, that for another 4 years. But you see, the election, the calculation has been done already. With Shettima backing Tinubu will be stronger where Shettima people are domiciled. Do you understand? The Kanuri people will give him block vote. Tinubu will get block votes in the southwest. And with what Tinubu is doing with Wike and the Senate president, and the kind of room is given to the South South, Tinubu will win favorably again in the South. Now, the Fulani people would have to go with the Southeast. That is if Obi or anybody from the Southeast does not come out again to be the spoiler. So, from my own calculation, that is the way it's going to go 2027. But
so that means they have to keep Obi relevant. Tinubu still needs to prop up Obi and keep him contained in the southeast, so the northwest cannot overpower.
They would have to continue to overlook whatever shenanigans Obi is doing for him to keep that space, and that's the politics. So I feel the Fulanis already see this happening to them. They already see it, and that is why they are complaining. And I know they will be doing their own inner meetings now to see how they can wrestle power. Obviously, if Tinubu does 8 years and is going to hand over, he will be handing over to Shettima off. And that is why El Rufai was eliminated. From my own point of view, anyways, that's just the way I see it. And I think one man is spot on with that analysis.
It's a long game.
All right, gentlemen, let's save a bit for the afternoon session. It's going to be I'm anticipating a blowout in the not the afternoon.
One man, if
Yes.
you don't mind, if you can reach out to maybe Ribadu and Hassan, if they can come, and some other Benny. Let us. I mean, those voices we have not heard from them recently. I mean, if there's a way you can reach out to them to come this evening, so we can hear their own opinion on this judgment, I think it's very important. And if we can bring Rudolph too, if possible, if we can join this evening, we would like to throw some questions to him. How does he feel? What has he learned from this? And particularly with what Kulanta was saying earlier, that maybe some other platform will learn the lesson that it is good to allow other voices on their platform, so that we can hear different opinion and on political matter, and not just only one opinion on the issue on a particular platform all the time. So
Yes, I've certainly I have all their numbers, or all the people you mentioned, so I'll be reaching out to them. I've even reached out to Rudolph in the course of this session. I suspect he might be listening to us. So Rudolph, if you want to pop in, have the last word. We're about to close out. Do that. But certainly, I'll invite them. Yes, I actually even
because one man, I don't mean to, because this platform, in everything we have done in this political issue, particularly on this presidential issue, this platform stand out to be the best among all the platforms. Everything that we said is going to happen is what actually happened. We predicted those that are going to be presidential candidate.
Yeah, but we have potent weapons now. When we have people like
APC,
Kulata and Enigmatic and Ogbeni, we have an
APC.
unfair advantage now.
Yeah, we predicted who is going to be presidential candidate on APC, on PDP, and who's going to win the election. The Kulata came out with a spreadsheet. We all juggled everything together. We did everything on a legal battle after the election. Ogbeni came, he break everything down. He told us what actually going to happen, and that is what happened. So
our margin of error is not more than a single digit. I don't think we erred in error more than single digit, which is quite impressive.
Yes.
So we said Obi was going to get roundabout, and he got maybe 1 million more. Ogbeni told us almost to the letter what will happen in the judicial process, and to the letter, it happened exactly like that.
So this platform, is the best, whether we like it or not. It's not based on sentiment or this thing, but on the truth, factual, and what everything that we have predicted here is what actually happened. So I mean, we have to say congratulations to ourselves. We have to say congratulations, to everybody for the good job we are doing on this platform. Yes, if we are not sentimental on issue, we just say it the way it is, and then
but we're switching gear, Janle Koko. From now on, is Operation Attack Tinubu. So
because yeah. We are no.
We are not interested in Tinubu. We're interested in Nigeria.
In Nigeria, yes.
So we're not in.
Yes.
So it's now none of these Bula Balu and Bulaba anymore. So it's Operation Attack Tinubu now.
No, we're going to be extraying every policy, every action is taken. We're going to x-ray it. We're going to, attack him when it is necessary. We're going to, criticize. We're going to, provide solution. That is what we're going to be doing on this platform. But at it is now, I think we stand out as the best among all the platform. Everything that we predicted that it's going to happen is what actually happened. So congratulations to us and congratulations to everybody. So bring all those people in the evening. I mean, reach out to them. Let us hear from them. And, we'll be looking forward to evening time. So.
All right, Ajale Kogo, let's save some for the evening time. So let me send the link again. So the evening session is already posted up. So go click on that link and bookmark it and get yourself ready with your popcorn. It's going to be an epic session. So as always, the support ever consistent. That's how you're right there, doing as it always does. Before making the decision to hop on Kulata, of course, he does that regularly. And Akim, he joins in as well, wishing he could join us. So you can join us later in the evening, Kulata. Ajale Koko, round it off with a couple more words.
So, look, I just want to urge everyone, those of us that come on the platform, to speak all the time, to continue the way we are doing. No bias, no what do you call it? No sentiment on issue, but rather factual all the time. We should continue on that basis, and we should be thorough in checking on the activity of the government now, because this is a time for us to come together to save that country. Tinubu, like some people said, might have a very good intention, but some people around him, they are after their own interests and not the interests of the country. So we should be using the platform to say it loud when we see him derailing, or when we observe that some of the government officials are doing wrong thing. We should say it loud on this platform, because people listen. People around the world listen. Even some of the government officials, they listen to us. So so this is the time for the nation is in dire need of cooperation from everybody to save it right now. And I want to thank our brothers at the comment section, particularly the super chatters like brother Alessandra Gomez, Ayo, Ike Egeame, and Kulata, and others that support this platform. Those that are very generous financially to this platform. So we will keep doing a very good job, and we will not disappoint Nigeria. We will stand up for the right of the people, for what is good for Nigerian people. That is what we will stand for on this platform. So one man, let's leave the rest till the evening time, and we'll come again and we'll continue that good job. Thank you.
All right, brilliant. Thank you. Thank you. So reconvene for the evening. Just a very micro final word from engineer who joins us after the fight is over between us and engineer now.
Thank you, one man. Thanks, Ajale Koko. Game over, Nigeria. Welcome our new president, and let's try to see how we can understand ourselves, and let's embrace ourselves. Let's love each other. I know there's a bit of issue of tribalism, bit of issue of religion. Well, let's please let that go, and let's begin to see how Nigeria can work together for everyone. And new president, congratulations. So no more argument, no more shouting, no more social media abuse. And thank you all. One man, respect you. Thank you very much.
All right, thank
and
you, engineer.
hopefully I see you tonight.
All right, brilliant. Thank you, engineer. So that's the crew, as you know them. Engineer Ajanle Koko Kulata. What more do you need?
Reach out to Baba Akure too.
Yes,
Those, everybody you can reach out to. That we started this platform. If you can let them come and say, their own opinion on the judgment of today. So we need all the old voices that you can reach out. Let them come in. Let us come and let them come and talk. We want to use this time to honor them, and because they contributed immensely to what we have achieved as a platform. Truthfulness, factual base, and no sentiment. So thank you, woman.
All right, brilliant. Let me wrap it up here, guys. Save some for the evening. So there it is. That's just the starter to the main course. Join us in the evening. The link to the evening session already in the comment section. So click on it, turn on your bell notification. It is going to be epic. So carry on the conversation in the comment section. This rests as a video on the platform. So we'll leave it here. I'll catch up with you in the evening. But here we say, what do we say?
Peace.
Peace.